All rise. Court is now in session. The Honorable Todd Stearns presiding.
Please remain standing. We'll let everybody get in. The sheriff will lead us in the pledge.
If everybody join me in the pledge. I pledge allegiance to the flag of the United States of America
and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Sheriff. Be seated, please.
Thank you, Sheriff Jackson, for leading us in the pledge. And I'd like to thank our County Commission Chairman, Raymond Wiggins, for meeting with you prior to the beginning of our program regarding voter registration. Good morning. My name is Tim Godwin, current president of the Escambia County Bar. And on behalf of our bar, I welcome you to our Law Day program. We missed having students, teachers, administrators, and school staff last year. And on behalf of our bar, I want to thank all of you for participating this year. Thank your teachers, administrators, superintendents. A couple of special thank yous. I'd like to say to Mr. Charles Godwin and our judges for coordinating this event with the schools, and Pepsi-Cola Bottling Company for their continued support in providing refreshments for students. They've been with us for years, and we appreciate that. And today we welcome high school seniors from Atmore Christian School, Escambia Academy, Escambia County High School, and Homeschooled Kids and Company. In 1958, President Dwight D. Eisenhower established Law Day as a day of national dedication to the principles of government under law. Law Day is observed every year to celebrate the role of law in our society and to cultivate a deeper understanding of the legal profession. The 2021 Law Day theme is Advancing the Rule of Law Now. The rule of law is the bedrock of American rights and liberties in times of calm and unrest alike. The 2021 Law Day theme reminds us that we, the people, share the responsibility to promote the rule of law, defend liberty, and pursue justice. Unlike many nations of the world, the U.S. was built around common ideals. The rule of law is central to those ideals. That is what limits the abuse of power in our nation, whether by an individual or a mob or the government. It reflects President John Adams' desire to establish a government of laws and not of men. It is how Thomas Paine distinguished us from the rest of the world, declaring that while in other nations the king is law, in America the law is king. Today, you'll see the rule of law in action. A defendant will be on trial for an alleged crime. You'll see that the defendant is represented by an attorney in the state of Alabama, who will be represented by an attorney. A judge will preside over the proceedings to make sure that they comply with procedural and substantive law. and the case will be decided by you, a jury. Before we get to the trial, we have introductions from our local bar, our attorney members. Let's just start over here with Mr. Brown.
Good morning, I'm Ben Brown from Atmore. I also serve as the city prosecutor for East Brewton, Alabama, and public defender for Fulton.
Good morning. My name is Steve Gilly, and I'm your district attorney.
I'm Kel Ransom. I'm an assistant public defender here in Escambia County.
Good morning, I'm Melissa Grosset. I practice at Oxmoor Law Firm. We have offices in Brewton and in Atmore, and I'm also an assistant district attorney.
I'm Kim Pettis, and I'm an assistant district attorney.
Good morning, I'm Jeremy Halsey. I have a solo practice here in Brewton.
Ernie White from Flomaton. My law practice is here in Brewton with Sierra White, who will introduce herself.
Go ahead.
I'm Jim Hart. I have a practice here in Brewton, and I also serve as a Fort Creek Indians public defender.
Mike here. I have a solo practice here in Brewton. My office is located directly behind the courthouse.
Good morning, my name is Dave Jordan. I'm with the firm Oxmoor. We have offices here in Brewton and in Atmore.
Good morning, I'm Brooks Garrett Jr. I practice law with the firm Thompson, Garrett and Hines with Ed Hines, Kirk Garrett, and Joe Witt, and look forward to seeing what y'all do today.
My name is Joe Witt. I practice at Thompson, Garrett, and Hines with Brooks, Ed, and Kirk. I'm also an assistant district attorney, Atmore City prosecutor, and municipal court judge in Florida.
Good morning, I'm Sierra White. I'm the newest member of our bar, and I'm the second half of White and White with my dad here in Brewton.
Charles Godwin. We practice in Atmore with my son Tim.
Thank you. Got everybody. Our first speaker is the Honorable Bradley Byrne, who is our drug court judge. Judge Byrne is a 1972 graduate of T.R. Miller. He's a 1976 graduate at the University of Southern Mississippi, a 1979 graduate at the University of Alabama School of Law, and he practiced law with Garrett, Thompson, and Hines from 1979 to 1986. From 1987 to 2014, he was a circuit judge for Escambia County. From 2002 to present, he presides over the Escambia County Drug Court. He served as president of the Alabama Circuit Judges Association and Alabama Association of Drug Court Professionals. As your drug court judge, Judge Byrne and his staff have an impeccable success rate. His work and the work of his staff have benefited our county immeasurably. This drug court program has changed lives for the better. Please welcome Judge Bradley Byrne.
Thank you, Mr. Godwin, and thank you to the Escambia County Bar Association. They do a wonderful job in putting on the Law Day program, and I commend them for that. I have been serving as the drug court judge since 2002 and been asked to just talk a little bit about the current state of the drug court crisis, or the drug crisis that we have, not only in Escambia County, but in our state and our nation. And at the outset, you're going to hear some very good speakers after me, and you can see why they've all risen to the top of their profession. So let me apologize to begin with, because I feel I'm going to be unable to really adequately describe to you the pain, the suffering, the devastation, and the regret that I've seen in the eyes and faces of so many people who stood right here in this courtroom before me as a judge, and it's all caused by drug addiction. I know what a lot of high school students would say, well, that's not going to be me, I'm not going to do that. No one ever plans to become addicted to a drug. I've not found one my life goal, my life plan to become addicted, but it does happen. 1 in 7 Americans suffer from some sort of drug addiction. And during the last year, ending September, during our coronavirus pandemic, we've lost 87,000 Americans, not from the virus, but from drug overdose. Most of that due to opioids. What I found, and I think what a lot of the research has found, is that addiction can happen suddenly, but for most people it's a process, and it begins in their teenage years. And one of the most accurate predictors of behavior and possible drug addiction is your peer group, who you hang around, who your friends are. And I heard a recovering addict say something that really stuck with me. He was talking to a group of high school students, and he said, "Show me your friends, and I'll show you your future." And I found that to be so very true in drug court and dealing with people who are suffering from addiction. You know, the human brain is probably the most amazing thing in the whole universe, at least in my opinion, I think it is. I mean, just look at what we've done. We've been able to send a spaceship to Mars, which is 192 million miles away, land a rover on the surface, and it's doing experiments and tests and sending that data back to Earth. So the human brain is quite amazing. And yet, illicit drugs alter the delicate balance of the brain and create new neural pathways. We're learning so much more about how addiction affects the brain. And in that process, it turns our brain into our enemy, where all that we want to do is obtain more of that drug. And the only vaccine that I know of for drug addiction is education. Without it, you can't be immune. So what I ask all of you to do, especially the high school students, is to educate yourself about addiction, what it does to the brain, what it does to the body, and then you'll be able to make good decisions and good choices about what you do in your life. Also make good choices about your friends, because they affect you in ways that you may not even realize. So be very careful about who you associate with. And the reason I say all this is because I don't want to see any of you, any of the high school students that are observing today, stand here and stand before a judge with that look of pain and regret in your eyes caused by addiction. So I hope you have a wonderful law day, and I hope you will heed the words that I've said this morning about addiction, because it is a problem, and it's going to continue to be a problem unless we educate young people about the dangers involved. So thank you very much, and thank you again to the Escambia County Bar Association. Thank you, Judge. Our next speaker is a special guest. His name is Robert Methvin Jr., Esquire. We all know him as Bob, the president of the Alabama State Bar, and we're pleased to have him here today. Bob is the managing shareholder of Methvin, Terrell, Yancey, Stevens, and Miller, PC. He practices in the areas of class actions and complex litigation, business litigation, insurance and annuity litigation, and mediation. Bob graduated from the University of Alabama with a BS degree in finance in 1991, where he was a member of Jason's Senior Men's Honorary. He received his Juris Doctor from Cumberland School of Law at Sanford University in 1994. While at Cumberland, he served as a member of the Trial Advocacy Board. Bob frequently lectures on business litigation and class action litigation, and is a registered mediator with the Alabama Center for Dispute Resolution. Bob also serves as consulting counsel and litigation counsel to a number of Alabama businesses. He has an AV peer review rating by Martindale-Hubbell. That's the highest rating that we can get as lawyers. He has routinely been named one of the top 50 lawyers in Alabama by Super Lawyers and Business Alabama magazine, and has also been consistently recognized by Best Lawyers in America for his
work in commercial litigation and insurance litigation. Most recently, Bob was recognized in the 2020 edition of Best Lawyers in America for his work in the following areas of practice: commercial litigation, litigation insurance, and mass torts litigation class action. And again, Mr. Methvin currently serves as president of the Alabama State Bar. We thank you so much for being here. Please welcome Bob Methvin.
Thank you so much, and I appreciate everybody having me here today. As was said, my name is Bob Methvin. I'm an attorney in Birmingham, and I'm the 145th president of the Alabama State Bar. I do want to thank Charles Godwin for all his efforts and the Escambia County Bar Association for putting this on, and this program is second to none. I also want to recognize your bar commissioner and my friend Kirk Garrett for all that he does for the Alabama State Bar. It's also good to be back in this courtroom. I tried a case in front of Judge Rice, I think 3 or 4 years ago in this courtroom, and so I spent a good bit of time down here, so it's good to be back. Charles asked me to tell y'all a little bit about the State Bar's role in our legal system, and also my role as president. So we call our organization the Alabama State Bar, or the Bar for short. So the bottom line is we are made up of every single lawyer in the state of Alabama. In fact, if you want to be a lawyer in Alabama, you have to be a member of the Bar Association. So what we do is we do things such as handle the admissions. So we administer the bar exam. So potential lawyers have to take and pass the bar exam in order to become a member of the Alabama State Bar. But we also look at a potential lawyer's character and fitness to make sure that he or she is not a danger to the public, and also make sure that he or she will do nothing to harm the administration of justice. We also discipline lawyers, and what that means is when lawyers do things wrong, we in-house, we have our own lawyers that handle discipline for those lawyers, and it can be anything from a public reprimand, which will be posted in a newspaper, all the way up to disbarment, which means if they did something really bad, we take their license to practice law, and they can't practice in Alabama anymore. We also have a number of member benefits that we provide for our lawyers, which is we track legislation that affects the practice of law or the administration of justice. We work with our Supreme Court to make sure that courts, just like this one, run efficiently, not only for lawyers, but for members of the public as well. And we also assist lawyers in their everyday practice of law throughout the state of Alabama. My job as the president of the State Bar is to lead the organization, which includes our 76 members of the Board of Bar Commissioners. So the Board of Bar Commissioners operates essentially like the Alabama legislature. What we do is we make policy for lawyers. We also make rules and regulations that affect the practice of law and that lawyers have to abide by. So that's my role as a State Bar president. One thing I want to emphasize to y'all is that your Law Day program here, put on by your Bar Association, is widely considered to be the best in Alabama, period. It's also nationally recognized as one of the best Law Day programs in the whole country. So this program's been going on for over 40 years, and more than 20,000 high school students have participated in exactly what y'all are going to do today and tomorrow. This program is truly unique because I don't know of any other one that allows high school seniors to actually sit as jurors and determine guilt or innocence. So your program has won the Alabama State Bar's Local Bar Award of Achievement numerous times, and Escambia County should be very proud of this program, and we at the State Bar consider it to be so great that when other counties talk about setting up their Law Day program, we send them here, because this is a model for a Law Day program that we're very proud of at the State Bar. And to all of you high school seniors out there, I'm excited about what y'all are going to experience today and tomorrow. What y'all need to realize, and you'll understand when you participate in it, is our jury trial system is the absolute best in the world, bar none. And it is the cornerstone of our democracy. So what better way to decide a legal dispute than a jury of one's peers? Our jury trial system has also been a model for other countries that are democratic countries that are setting up their own government, and so they use our jury trial system as a model in those countries as well. So I'll leave you with this. After you participate in the next day or so, and you decide that you want to know more about the practice of law, or if you decide maybe you want to be a lawyer, I want you to know you can, if you want to call me and talk to me about it, I can kind of guide you and tell you what I think you need to do. You can call me at the State Bar Office in Montgomery. You can call me at Meth and Terrell at my law office in Birmingham. I'm always excited to talk to anybody about what I consider to be the greatest profession in this country, and that's the legal profession. So if you decide you want more information, look me up. I'll be happy to talk to you. So again, thank y'all all for having me, and Charles, thank you so much for inviting me to speak.
Our guest speaker today is Laura Canary, Esquire, General Counsel, Retirement Systems of Alabama. She is a 1978 graduate of Huntington College, where she majored in Business Administration and History. Ms. Canary earned a law degree from the University of Alabama School of Law in 1981. She currently serves as General Counsel for the Retirement Systems of Alabama. You may have heard it referred to as RSA, a position she has held since January 2012. She acts as Chief Counsel for the RSA, a 350,000 member, $40 billion public pension fund for Alabama's teachers, educational support employees, state employees, and local employees. She additionally is General Counsel for the Alabama's Public Education Employees Health Insurance Program, a group health insurance plan that covers 300,000 active and retired education employees and their dependents, and RSA-1, a $2 billion deferred compensation plan. She and the RSA Legal Division staff are responsible for providing legal advice to RSA's governing boards, executives, and administrative staff, handling litigation, resolving operational legal issues, drafting contracts, overseeing legislative matters, designing and implementing legal policy positions for RSA, and handling all other legal matters affecting RSA's operations. In 2001, she was appointed by President George W. Bush and confirmed by the U.S. Senate as the U.S. Attorney for the Middle District of Alabama. She was the first woman to serve as U.S. Attorney in Alabama and the longest serving in the Middle District, holding that office for almost 10 years. Ms. Canary chaired the National Child Exploitation Committee and crafted a program to prevent, deter, and aggressively prosecute child sexual exploitation and abuse. That program, Project Save Childhood, was implemented throughout the United States in 2006 and remains a national priority initiative for the U.S. Department of Justice through subsequent administrations. She also served on the Attorney General's Advisory Committee, which provides policy advice to the U.S. Attorney General. During her tenure as U.S. Attorney, the Middle District's office won a national award for its program combating gun violence and was deemed a model program. Prior to her tenure as U.S. Attorney, she had extensive experience as a civil litigator for the U.S. Department of Justice and the Alabama Attorney General's Office. In 2011, she received the Huntington College Alumni Achievement Award. She currently serves as chair of the Huntington College Board of Trustees and formerly served as vice chair and as chair of the Academic Affairs Committee. She has also served on the Board of Trustees of the Montgomery Academy, the Capri Theater, and First United Methodist Church, where she taught 5th grade Sunday school for over 15 years. She is an active member of the National Association of Former U.S. Attorneys. Ms. Canary is a graduate of Leadership Alabama, Class 25. Ms. Canary is a native of Uriah, Alabama, and a resident of Montgomery. She is married to William J. Canary and has 2 children, Will, 27, and Margaret, 23. Please, if you will, help me welcome our special guest speaker today, Ms. Laura Canary.
Thank you, Tim, for that very kind introduction. And I'm glad to be down here in South Alabama where they know it is Uriah, not Uriah. I'm honored to be here today with you to celebrate Law Day. And I have to commend also the Escambia County Bar Association, especially Charles and Tim Godwin, for their roles in putting on this program, which surely is the best program in the United States. And y'all are very fortunate to be able to be here too. As you heard, the theme of Law Day this year is advancing the rule of law now. That's a really big topic to cover in a very short period of time, but I promise you I will be short. I want to give you my perspective today on the critical importance of the rule of law in a free society and how that impacts you. So really what I'm going to talk about today is, what has the rule of law got to do with me? I know a lot of you may not have used that term a lot, you may not see it often, but it really is part of our daily lives in ways that we take for granted and that need to be protected. And I want to discuss also today some ways that you might help protect and strengthen the rule of law. So what am I talking about when I say the rule of law? And what does it have to do with you in your everyday life? The American Bar Association describes it in lofty terms like this. The rule of law is a set of principles or ideals for ensuring an orderly and just society. Many countries throughout the world strive to uphold the rule of law where no one is above the law, everyone is treated equally under the law, everyone is held accountable to the same laws, there are clear and fair processes for enforcing laws, there is an independent judiciary, and human rights are guaranteed for all. To me, the rule of law in this country embodies several critical principles. First and foremost, there's a fundamental agreement in our society that we will abide by law. And that we shouldn't, and those who don't, should be subject to criminal and civil penalties. Our laws are enacted by elected representatives who are responsible to and answerable to the people. The laws are applied equally, and penalties are applied equally by an independent judiciary without regard to race, sex, national origin, religion, position, wealth, or any other category. This is embodied in the principle that no man or woman is above the law, but also no man and woman are below the law. And finally, most importantly, we have certain inalienable rights guaranteed by our Constitution and upon which no law can infringe. So when you think about it, the rule of law is inherent in our daily lives. If you drive to the grocery store to buy a gallon of milk, the law requires you to stop at stop signs, wear your seatbelt, and obey other traffic laws. You purchase milk that is produced in accordance with laws and regulations concerning its purity and pasteurization. The plastic jug containing the milk was produced in a factory that had to comply with the rules governing how it treats people working in the factory regarding the hours they work, their pay, and safety rules in the workplace. So how would life be if everybody ignored all these rules and regulations? And how would society function? So going back to your trip to the store, traffic laws and car safety regulations are there so you can safely make the journey to the store and protect others who are on the road. Health laws governing the production of milk allow consumers to purchase milk and be assured that they won't get sick when they drink it. And labor laws ensure the health and safety of workers and that they are paid a fair wage. Former Prime Minister Margaret Thatcher once said, "In order to be considered truly free, countries must have a deep love of liberty and an abiding respect for the rule of law." So how does this rule of law, where we have all these rules and regulations that we have to abide by, make us more free? Why would we choose to abide by the rule of law? The rule of law attempts to balance individual rights against the safety and rights of others. A judge once described the rule of law by saying that the right to swing your fist stops just short of my nose. So the rule of law is meant to define the boundary between those individual rights and the rights of others. We wouldn't be free to pursue happiness as our Constitution guarantees if we lived in a constant state of fear of the actions of people who won't abide by the rules. People can murder, steal, cheat, violate contracts, harm you, and do all manner of horrible things, but for the rule of law and the prospect of consequences for those actions. So things that happen in our society as it's set up, we have prosecutions for criminal misconduct and civil lawsuits where you can get money damages for civil law. Those consequences act as a check on the conduct of those who don't respect the law, and it allows our society to function as it does. In countries where the leaders have no respect for the rule of law, they are despots and dictators, and they steal from the populace and violate human rights on a regular basis. On papers, these countries also usually have constitutions that guarantee rights, and they have laws on the books that prohibit that sort of conduct. But the difference between those countries and the United States is that they have no effective check on the power of their leadership. And there's no institution in those countries strong enough or independent enough to enforce the law. So in the U.S., as you all know, the government divides its power among three branches of government. And that's to keep a check on one another. For instance, even the president is bound to follow court rulings of the judiciary regarding whether his conduct is legal. That's why it's so important to have an independent judiciary to protect individual rights and apply the laws equally. And it's also important to have a legislative branch that creates the laws because they are elected by and responsible to citizens. And the executive branch's role is to implement those laws and make sure they're meaningful and that they actually apply in our society. And finally, our Constitution is what we look to for the ultimate protection of individual rights. So as you've heard, my entire career has been in government service. So when I was U.S. Attorney, my role as a federal prosecutor was in the executive branch, and I played a part in the enforcement of the rule of law. Congress enacts federal criminal law, and as a prosecutor, it's my job to enforce the law by prosecuting people who were accused with cause of violating criminal laws. Those prosecutions occurred in federal court, where an independent judge acts as a referee to ensure that the law and Constitution are followed. And you should know that those judges are not on the side of the prosecution or on the defendant. And if anything, they're on the side of the constitutional rights of that defendant. So that judge is there to make sure the rules are followed as they should be. The conviction of someone can only occur when a jury of their peers agrees unanimously that they are guilty of the crime. And by the way, y'all are going to have probably the best civics lessons I've ever heard of by participating in this criminal trial today. But let me be clear, I'm not saying as a society we've always done the right thing. Perfect adherence to the rule of law is an ideal that we strive to meet, but our implementation has been at times deeply flawed. Our country is made up of people, and people are imperfect. This means that in the past we have woefully failed many of our citizens with respect to the fair enforcement of the law and protection of personal lives. And the only thing that can save us from repeating these mistakes and instead protect everyone, including those in the minority, is to respect and to submit to the rule of law. So in closing, let's talk about what you can do to help prevent those shortcomings and strengthen our country. To do your part as a citizen, you should choose to abide by the rule of law. Vote, serve on juries, run for office, support fair and just officials, be mindful and protective of the rights of those who are different from you or who have different political views or religious beliefs. In short, respect the law even when you don't agree with it. If you think the law is unjust or unfair or unconstitutional, work to challenge it and have it changed. President Dwight Eisenhower, who I did not know before Tim told us, started Law Day. When he was General Eisenhower, he helped us lead the U.S. to victory in World War II over Nazism. He best illustrated the importance of the rule of law when he stated, "The clearest way to show what the rule of law means to us in everyday life is to recall what has happened when there is no rule of law." Thank you for your attention. Nice being here with you.
At this point in the program, our circuit judge, Judge Todd Stearns, is going to take up. Your Honor.
Thank you, Mr. Godwin. We appreciate everybody being here. Special thank you to Mr. Charles Godwin, who, as you heard, has coordinated this program for many years, and he does an excellent job, and this program is only as good as it is because of Mr. Godwin. So thank you, Mr. Godwin. Thank you, Tim. Thank you, Judge Byrne, for being here and speaking, taking time from your schedule. Thanks to Bob Method for coming down, and thank you, Mr. Jerry, for your words. And we appreciate you coming today. I want to introduce our court personnel. We have our other circuit judge, who's the presiding circuit judge, Jeff White, immediately to my right. We have District Judge Eric Cole, and he will be speaking to you a little later this morning. I don't see our probate judge here, but our probate judge is Doug Agerton, and he was unable to join us this morning, but he is normally here and definitely supports the program. Our circuit clerk, immediately to my left, is John Robert Fountain. We have our court reporter, Denise Carly. She is my court reporter. My judicial assistant is Carrie Powell. And Judge Cole's judicial assistant is Mike Clayton. Judge White's judicial assistant is Jody Wilson. We have our jury coordinator, Ms. Lindy Young. I see we have our assistants from the Public Defender's Office. We have Chelsea Ferguson and Samantha Hanks. We've already been introduced to the sheriff this morning. Mr. Wiggins from the County Commission is here. Thank you for coming and participating with us, Mr. Wiggins. We also have another county commissioner who's come in. We have Kareem Reynolds. He's your District 5 commissioner. He's also a practicing attorney and has an office in Atmore. Cindy Jackson is a school board member, and we appreciate her being here this morning. This is a unique program this morning. As you heard, our Law Day program allows you to participate in a real trial
to broadcast because of the social distancing requirements. You also have the distinction this morning of being the first jury trial since jury trials were suspended by the Supreme Court last year. So you will be the first jury to actually be able to hear a case since the Alabama Supreme Court allowed us to restart having jury trials. So we certainly appreciate that, the fact that you are here. I do want to thank Superintendent John Knott from the Escambia County School Board and also Superintendent Ken Varner from the city of Brewton. They have worked with us to enable this Law Day program to be put on this year with the constraints about social distancing. Normally, the courtroom would be packed with seniors, but because of the social distancing restraints that we're still under, we only were able to bring the jurors this morning, so the superintendents helped provide the technology to allow the rest of the seniors to participate virtually. So thank you, Superintendent Knott. We appreciate your assistance, and thank you to our technology personnel this morning for broadcasting for us. We have everybody introduced, so at this time the attorneys may be excused. And the attorneys who are trying the case this morning, we'll allow them a few moments. Thank you, Mr. Governor. We're going to take a few moments to reposition the table. So ordinarily, you as jurors would be up here in the jury box. As you saw when you came in, you were directed to sit on pieces of tape, so that's to keep y'all socially distanced within the recommended CDC distance. Ordinarily, you would be up here in the jury box, but because of the social distancing restrictions, until those are lifted, this is where all of our juries are going to be seated. Here's the case, you will be in here, and you will be deliberating in here. I want to thank Webb Nall here, who's with Pepsi. At the close of the state's case, you will be allowed to have a recess, and Mr. Nall has refreshments for us during the recess, and at that time I will give you special instructions about what to do during the recess. time, the circuit clerk, Mr. Fountain, is going to call the roll. Jurors. So if you will, raise your hand and let us know that you're here.
Samantha Forkins, Amaya Holt, Jamarcus Leslie, Brianna McGowan, Stefano Schubring, Caprice Murphy, Hayden Weaver, Destiny Brown, La Teresa Knight, Isaiah Mason, Aaron Calva, Lillian Bonner, Ruba Nix, Austin Washington.
Thank you, Mr. Fountain. At this time, if the jurors would stand, raise your right hands and I'll swear you in. Do you solemnly swear or affirm that you will well and truly try all issues joined between the defendants and the state of Alabama and render a true verdict thereon according to the law and evidence, so help you God? Okay, you are sworn, you may be seated. Ladies and gentlemen of the jury, before proceeding this morning, I want to explain some of the rules of procedure that will be followed by you and me during the trial of this case. This is a criminal case. This is a real jury trial with criminal charges, and the procedure of trial will be as follows. First, the attorneys will be allowed to make opening statements to you. Counsel for the state of Alabama will make their opening statement of their case first. Counsel for the defendant will then respond with a statement for their defense. Each side will be confined to an outline of the case and a statement of what they expect the evidence to show, more like a movie preview of what they expect the evidence that you will hear. Now, these statements are not evidence. They are given to you to familiarize you with the case so that you will be acquainted with the contentions of each of the parties. In receiving evidence, you should bear in mind, as officers of the court, the attorneys have a duty to present evidence on behalf of the parties that they represent. They have a duty to make objections as they deem proper and to fully argue their party's cause. An attorney's statements are not evidence, but are to help you understand the evidence and to apply the law. Therefore, you should consider in your verdict only statements supported by the evidence and by the law as given to you by the court. Likewise, statements made by the court are not evidence and are not to be so considered by you. Following the opening statements by counsel, witnesses will first be called by the state of Alabama to testify. After the state has presented witnesses, the defendant will then be permitted to call witnesses to testify. All witnesses will be sworn and will testify under oath. The testimony that you hear from the witnesses from the witness stand will be evidence. There may be exhibits offered, and if they're received by the court, those exhibits will be evidence. It will be upon all of this evidence that you use to arrive at your verdict. Now, when a judge and a jury sit together as a court of law, it is the duty of the judge, my duty, to see that the trial progresses in an orderly fashion. It is my duty to rule upon all legal matters that are presented, to define the issues involved, and to instruct you, the jury, as to the applicable law. It will be your duty as jurors to follow the law as stated to you by me, the judge. You will therefore render a verdict in accordance with the facts as you determine them from the evidence and the law as given to you by the court. You, as the jury, will be the sole and exclusive judges of the facts. You will decide the facts. It will be your duty to consider the testimony with the view of determining what the true facts are. In doing so, you may accept or reject any part of the testimony of any witness and accept only the testimony you consider worthy of belief. In determining what the true facts are from the evidence, you may take into consideration any natural interest or bias a witness may have as a result of connection to this case. You may take into consideration the interest or bias a witness may have shown while testifying. You may take into consideration the demeanor of any witness as to whether the witness has apparently testified frankly or evasively. You may take into consideration any matter as you would in your everyday affairs in passing of the truthfulness and accuracy of the testimony. Weigh the testimony in light of your common observation and experience and reach a verdict based upon the truth as you determine it to be from all of the evidence. Now, during this trial, you will hear objections. That is part of the attorney's job, to object if they think something should not be allowed to be introduced or referred to. It's my job to rule on the objections by the attorney as to the admissibility of testimony and other evidence. You should not concern yourself with the reasons for my rulings, since they are controlled and required by rules of law. You are not to speculate as to the possible answers to questions which I do not require to be answered. The overruling of objections to evidence is not intended to indicate the weight you should give such evidence. Occasionally during the course of the proceedings, it may become necessary for me to confer with the attorneys outside of your presence or outside of your hearing. Should I call counsel to the bench or excuse you from the courtroom, it will be to resolve a legal point or some other legal matter which might not be proper for you to hear or consider. If that happens, you should not speculate on the content of what's going on in that conference, nor to allow the fact that the conference or any inference you may draw from it affect your verdict. Now, once all the evidence is had, following the close of all the evidence in this case, counsel will be allowed to address you once more in closing arguments. They will discuss the evidence and all reasonable inferences to be drawn therefrom to help guide you to a true and just verdict. Counsel for the state will open the arguments. The defendants will follow, and because the state has the burden of proof, they are allowed to have the last say. At the close of the arguments, I will state to you the applicable law to guide you in arriving at your verdict. Upon retiring to the jury room to consider your verdict, you will elect one of your number as foreperson to moderate your discussions and to sign and return to the court the verdict arrived by you. I will now read to you the charges. Mr. Buford Jason Lowry is charged by complaint with unlawfully operating a motor vehicle or other vehicle at or near Appleton Road within the county of Escambia at or near Mason Mill Pond Road in violation of section 32A-5A-192A2, duly adopted and enforced at the time the offense was committed.
This is called the offense of driving under the influence, and that is alleged to have happened on November 5th of 2020. Mr. Lowry has also been charged by a complaint with failure to wear a safety belt. The complaint alleges that on November 5th, 2020, that Mr. Lowry did unlawfully operate a motor vehicle or other vehicle at or near Appleton Road within the county of Escambia, at or near Mason Mill Pond Road, in violation of section 32-5B-4, Code of Alabama, duly adopted and enforced at the time the offense was committed. And again, that's the charge of failing to wear a safety belt, or commonly known as failing to wear a seatbelt. Mr. Lowry is also charged with what is called an open container violation, and that is by complaint which reads that on November 5th of 2020 that Mr. Lowry did unlawfully operate a motor vehicle or other vehicle at or near Appleton Road within the county of Escambia, at or near Mason Mill Pond Road, in violation of section 32-5A-330 of the Code of Alabama, duly adopted and enforced at the time the offense was committed, and that is known as an open container violation. Those will conclude my opening instructions. To each of those charges, Mr. Lowry has said not guilty, and that is why we're here today. And you are about to hear the real trial of the state of Alabama versus Mr. Lowry. Attorneys, state, satisfied with the court's opening instructions?
Yes, Your Honor.
Yes.
Okay. State ready to proceed?
Yes, Your Honor.
Yes,
Defense?
sir.
Okay. At this time, let you introduce yourselves. Mr. Witt will start.
My name is Joe Witt. I'm an assistant district attorney for the state of Alabama and Escambia County.
And I'm Melissa Grosson, and I'm also an assistant district attorney for Escambia County.
Ms. White?
I'm Sierra White, an attorney here in Brewton, and to my right is my father, Ernie White. We are White and White right across the street over here, and this is our client, Mr. Buford Lowry.
Thank you, Ms. White. Mr. Witt? Ms. Grosso? You may proceed with the opening statement.
Yes, Your Honor. Ladies and gentlemen of the jury, it is my job to prove beyond a reasonable doubt that Buford Jason Lowry did commit the crime of drug.
That's not proper opening statement. He's supposed to outline what he expects the evidence to show. If you're going to tell folks about proof beyond a reasonable doubt, that's improper at this time.
Your Honor, I can tell them what I have to prove.
All right. Objection overruled. Proceed, Mr. Witt.
I can prove beyond a reasonable doubt that Jason Lowry did commit the crime of driving under the influence of alcohol, having an open container of alcohol in his vehicle, and that he did not wear a safety belt. The judge already informed you that this is like a movie preview. So I want you to envision that you're in a movie, and you're it's November the 5th, 2020, around 8 p.m. at night. You've just left your boyfriend or girlfriend's house, or
Objection, that's not telling the jury what he expects to prove. He's talking about a movie now.
Your Honor, you did say it was a movie preview.
We are in opening statements. Mr. Witt, please confine to what you expect your evidence to show.
Like I said, on November the 5th, 2020, at around 8 p.m., Mr. Lowry was cruising the back roads. He had a cooler of the beer in the back of his truck. He was drinking. He had a few beers even before he came upon a roadblock. He comes upon the roadblock. The officer walks up to the vehicle, asks him a few questions. The roadblock is there for an equipment check. And the officer sees an open can of Natty Light in the cup holder, and he can smell the odor of beer coming out of the vehicle. So he knows then that that Mr. Lowry had been drinking. So he asked Mr. Lowry to step out of the vehicle, and he runs through a series of tests to determine, possibly what level of the amount of alcohol that he was drinking. And Mr. Lowry even tells him that he's had a couple beers. You'll hear testimony that that's normally what every drunk driver that's pulled over will testify to.
Objection to what they testify to in other cases, we ask the prosecution on behalf of the state of Alabama to confine himself to what he expects the evidence to show. He's not going to get that into evidence, what he just said.
Your Honor, we haven't even got to that, so how does he know that I'm going to do that into evidence?
You can't get into what people say in other trials. That's not admissible. That's not proper opening argument.
I'm not arguing with you. We're going to get into it the trials.
Overruled. Find your statements.
Yes, Your Honor. So at that point, Mr. Trooper Jeremy Elam starts giving the field sobriety test, and during the course of that field sobriety test, Mr. Lowry stumbles and skips and almost falls over, and you'll also get to see the video, and you'll see how he does performs on these field sobriety tests. You'll also hear that later on he's taken to the Escambia County Jail to take to blow into what's called the drager, and that's a machine that determines blood alcohol content. The legal limit in Alabama for blood alcohol content is 0.08, and you'll hear that Mr. Lowry blew above a 0.08. You'll need to envision that if Mr. Lowry had been allowed to continue to drive on, he had, like I said, a cooler full of beer. If he'd have drive on, he could have, had a wreck. He could have
done, Judge, that is speculation. He's supposed to limit his opening argument to an outline of what he expects the facts to show. Now he's going to speculate on what might have happened. That's totally improper.
Mr. Witt, response?
Yes, Your Honor. I'm trying to inform the jury on, the dangers of driving under the influence of alcohol.
That's more appropriate for closing. Totally improper for opening.
Mr. Witt, we must sustain Mr. White's objections. Don't get into argument at this point. Find yourself what you expect your evidence to show.
Yes, sir. I will definitely say that in closing.
Thank you, Mr. Witt.
So, ladies and gentlemen, after you hear the evidence today, and after you hear what the White family is going to tell you and try to bring out.
There's objection to the White family reference. We're attorneys. We should refer to us as Attorney White and Attorney White. I'm not going to call him the Witt family. He should change one letter in that last name. He'd be part of our family.
Melissa's not in my family. Y'all are family.
And proud to be.
Go ahead.
All right. Continue on, Mr. Witt.
after you hear all the evidence today, I think you will be honor bound to find that we have proven beyond a reasonable doubt that Jason Lowry is guilty of driving under the influence of alcohol, is guilty of having an open container of alcohol, and is guilty of not wearing a seatbelt. Thank you.
Mr. White, Ms. White?
May it please the court. Innocent until proven guilty. That's the most important thing I want y'all to remember today, okay? It's one of the most important concepts in the American legal system. And what it means is that a person who is charged with a crime is considered innocent until the government proves beyond a reasonable doubt that they are guilty of committing that crime. Okay? Innocent until proven guilty. Proven guilty. Members of the jury, I represent, along with my father, Mr. Buford Jason Lowry.
Objection. Your Honor, they already said they didn't want to be called family, and here she's referring to her co-counsel as her father.
Judge, our objection was being referred to as the White family. He is my father. I can certainly introduce him as
And they are family.
Okay. Let's be clear right now that Mr. White is Sierra White's father. So they are blood related, but they are also a practicing attorney representing Mr. Lowry this morning. Now that that's out of the way, let's confine ourselves to what the facts are.
Thank you, Judge. So we represent Mr. Lowry. As you've been told, he's charged with driving under the influence of alcohol, not wearing a seatbelt, and an open container violation. But he's innocent until proven guilty. And because of that, it's the prosecution's job to persuade you beyond a reasonable doubt that you, not the prosecutor, not the police officer, not the Drager machine, but you know with a certainty that Mr. Lowry was indeed...
Objection, that's not what the rule is. It's reasonable doubt, not within the certainty.
I did say reasonable doubt, Judge, beyond a reasonable doubt.
Again, we're still in open statement, so
Yes.
let's move on.
Thank you. So you have to be convinced, beyond a reasonable doubt, that Mr. Lowry was indeed driving under the influence of alcohol. And if you're not convinced, you cannot return a guilty verdict, right? Now, members of the jury, you have a very important job. I'm sure you've learned that the jury in the American legal system is a very important thing. Your job is to pay close attention to the evidence and consider it and then make a decision. So the evidence is going to show today that Mr. Lowry came upon a DUI checkpoint about a mile from his house. It was about 8:20 p.m. The evidence is going to show that Mr. Lowry was extremely polite and cooperative with the officer when the officer asked him to pull to the side of the road. The evidence will show that Mr. Lowry performed all of the field sobriety tests, including walking a line that the officer drew in the dirt with his foot. He did that while his neighbors are driving down the street past him. So while Mr. Lowry has nothing to prove in this case and the burden is all on the state, I do want you to consider the fear and intimidation that he probably felt when he was stopped, pulled over by the police less than a mile from his home after dark. I also want you to consider the frustration and the embarrassment he had to feel when he was doing the field sobriety tests in the dirt on the side of the road while people he knows are driving by and the blue lights were flashing behind him. So not only do you need to keep in mind that he's innocent until proven guilty, but also keep in mind that drinking and then driving is not illegal. It's not illegal. It only becomes illegal if a person consumes so much alcohol that their ability to safely operate a motor vehicle is impaired. Okay, so you have to find that he was so impaired that he could not safely operate a motor vehicle.
Objection, that's not a proper statement of the law.
I think it is, Judge.
Okay. I'm going to overrule the objection, but I want to instruct the jury that I will instruct you at the close of all the evidence as to what the applicable law is. Please
Thank you.
continue.
Thank you. So members of the jury, pay close attention to the evidence today, okay? And don't forget that the burden is entirely on the state of Alabama to prove that Mr. Lowry is guilty. Prove it to you beyond a reasonable doubt. And if you are not convinced beyond a reasonable doubt, then you must find him not guilty. We look forward to presenting this case to you today. Thank you.
Rebuttal from the state.
Your Honor, we'll move forward.
All right. We need a moment to.
Oh, yeah.
Move Cody.
What do you want to
Yeah, move the mic around. Plans to. Ladies and gentlemen of the jury, the attorneys are going to take a moment to, they expect some of the evidence, maybe a video, we're not there yet. If the video is admitted, then they're going to go ahead and get the TV equipment, safety.
Can y'all still see? Let's just turn it sideways for now. Good.
Can y'all see the witness chair with me sitting right here? You can? Does everybody can see it with me sitting right here?
The witness is gonna be right here. Y'all all see that?
State ready to call us first witness.
State's ready, Your Honor.
All right, call you first witness.
I'd like to call Jeremy Ely.
You can stop right there, raise your right hand. Swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. All right, if you will have a seat, please adjust that microphone where we can hear you. And for the benefit of our court reporter, ladies and gentlemen, our court reporter, Ms. Carly, has to take down everything. And it's bad enough people trying to talk through a mask, but if she can't clearly hear what the witness said, a lot of times they have to rely on lip reading, and you cannot do that with a mask on. So we've asked the officer to lower his mask for the purposes of helping our court reporter get this down on the record. So, Mr. Witt, are you ready?
Yes, Your Honor.
All right. You may question your witness.
State your name to the court.
Trooper Jerry Eagle
And where are you employed?
with the Alabama Law Enforcement Agency,
How long have you been there?
approximately 3 years.
Okay. Do you have any prior law enforcement act before that?
No, sir.
Okay. How old are you, Trevor?
Sir?
How old are you, sir?
29.
What'd you do after high school?
I was a grocery store manager.
Pull that microphone up a little closer to it, try to speak into that.
Yes, sir. Can you hear me now better?
What made you decide to become a trooper?
Well, my father was a state trooper for 26 years, so I figured you can't beat him, join him, right?
All right. And you're employed with Leah, is that correct?
Correct.
Alabama Law Enforcement
Agency.
Briefly describe your duties with Leah.
To protect the citizens of the state of Alabama and enforce the state codes.
Okay. And is driving under the influence of alcohol, having an open container of alcohol in a vehicle, and not wearing a seatbelt, are those violations of the state code?
Yes, sir, they are.
Were you on duty on November the 5th, 2020?
Yes, sir.
And approximately 8:20 p.m. Were you on duty at that time?
Yes, sir, I was.
Did you happen to come in contact with Mr. Jason Lowry at that time?
Yes, sir, I did.
Is he in the courtroom today?
Yes, sir.
Can you point him out?
Yes, sir.
And the gentleman in the teal light blue shirt?
Yes, sir.
Let the record reflect that he's pointed out in this minute.
The record shows so reflect.
Where did you come in contact with this?
On Appleton Road, County Road 49, and Basin Mill Pond Road.
Okay. Is that in Escambia County, Alabama?
Yes, sir.
What were you doing when you came in contact?
We were doing a system of equipment checks. We were doing a driver's safety checkpoint to where we make sure that everybody has their driver's license, their proof of insurance, and registration.
Okay. And were y'all checking every vehicle that came through?
Yes, sir.
Did anyone at the scene have the authority to let anybody just drive on through?
No, sir.
And who authorized the check?
We advertise it once a year.
Objection, I'm responsible. He said, who approved that call for the name?
State Alabama.
Objection, you're responsible. Your rules on my objection.
State trooper, for purposes, if you're an objection, just stop talking until I rule on the objection.
Yes, sir.
All right. I'm going to sustain as to the non-responsive.
Yes, sir. What authority authorized you to run the check?
The state of Alabama.
And would that have been someone higher up in the law enforcement?
Objection, you leave the witness, man. He asked him who, he needs to say who. He said, state of Alabama.
Don't leave your witness.
Who within the state of Alabama authorized you to run this check?
Supervisors.
Did Mr. Lowry approach the checkpoint, or did y'all see him before he got to the checkpoint?
He drove up to safety checkpoint.
Okay. And when he drove up to the checkpoint, did he cooperate? What was?
Yes, sir. Mr. Lowry drove up to the checkpoint, asked for his driver's license and proof of insurance and registration. Mr. Lowry.
Judge is non-responsive to objection. He asked if he cooperated. He said yes.
Ask another question.
Yes, sir. Did you approach his vehicle?
Yes, sir.
Did you ask him at that point to step out of the vehicle, or were you asking him to roll the window down?
Yes, sir. He rolled his window down. When I observed, Mr. Lowry had no seatbelt on and had an open container inside the vehicle.
And you saw that open container as soon as he rolled down the window?
Yes, sir.
Did you tell what the open container was?
Yes, sir.
And was it open container of Pepsi?
No, sir.
What was it open container of?
A natural light.
And is that an alcoholic beverage?
Yes, sir.
And is that commonly referred to as a natty light?
Yes, sir.
Is there any other, do you have any other, I guess, observations of whether or not he had been drinking?
Yes, sir. Mr. Lowry had bloodshot eyes. He had a slurred speech. His eyes were real watery, and the odor of alcohol was inside the view.
You smell beer?
Alcohol, yes, sir.
Did you serve anything else in the Bennett's?
I observed in the back of the cooler.
And did you, back up a minute, did Mr. Lowry, did he give you the driver's license registration when you were in school?
No, sir.
What was his reason for not giving it to you?
He was having a hard time finding his ID.
Did you ask him what was in the cooler?
Yes, sir.
And what did he tell you?
He stated more alcohol.
Sorry, stated what?
More alcohol.
Did he say alcohol or did he say beer?
Beer.
But he said beer or alcohol?
Both are the same.
No, that's not the question, young man. Did you say beer or did you say alcohol?
Objection. It's my time to direct examination. He can
Well, I'm
say
trying to
Mr.
get his
Cross.
answer, Judge, and I don't understand his answer.
Well, he'll have to
I'll take him
cross.
on cross-examination, that's fine.
Go ahead, Mr. Wood.
Thank you. Did he tell you how much was in the cooler?
I do not recall. I'm immediately sick.
Objection, answer the question.
That's another question, Mr. Wood.
Did you ask him how many he'd been drinking?
Yes, sir.
What did he tell you?
He stated a couple.
How often do you ask people that you stop if they've been drinking?
If I see several indicators that lead up to a
That's
suspicion.
not relevant, objection, that is not relevant, Judge. That is not proper in this trial. This is a trial on its own merits, its own facts. What he does in other cases is not relevant to this case.
I'm trying to lay a foundation for future questions, Your Honor.
We can lay it outside the presence of the jury.
And we're going to overrule, I think he can testify to his investigation as part of the procedure. Certainly, you'll have wide latitude on cross-examination.
Yes.
How often do you ask that question?
When I suspect a series of impairment that has happened, I have to start asking.
Objection. You got to stop talking when I object. You've already instructed him to do that one time, Judge. How many times you gonna take?
Trooper, it's hard for Ms. Carly is the best court reporter that I know. It's hard for her to get down 2 or 3 people talking at the same time.
Yes, sir.
Just, what's your objection, Mr. White?
I don't even know, Judge, I forgot.
I don't answer the question and answer.
Something about how often does he ask people how much they have to drink?
Okay, I think he answered that.
And is there a typical answer in that?
Yes, sir.
Objection to what's typical, Judge. Objection to what's typical.
I didn't ask him what was typical. I asked, does he get a typical answer?
And that's not relevant to this case. That would be hearsay.
If it's further investigation, Your Honor.
Still would be hearsay. I don't care if it's further investigation or not, you can't get into hearsay. What other people tell him in other cases is not relevant here. They could say, yeah, I drank 16 beers and I'm drunk. That's not relevant to this case.
Okay. While on sustain, Trooper can talk about his investigation, but what somebody else has said in another case, that's not proper.
upon several indicators.
Judge, you sustain the objection.
Wait till Mr. Witt asks you a question.
Thank you.
After he had told you he had a couple, what did you proceed?
Asked Mr. Lowry to pull over to the side of the road where we can do further investigation.
Okay. At that time, did you have probable cause that he had been drinking and driving?
Yes, sir.
And what was that probable cause?
The odor of alcohol, the bloodshot eyes, the slurred speech, the open container violation. In the statement that he stated that he had a couple of alcohol beverages.
Did he tell you where he was coming from?
Yes, sir.
Where was he coming
From a dirt food.
from? He just said he was coming from the dirt
He
bag.
said he was right.
He was just riding around drinking beer.
Yes, sir.
After you asked him to pull over the side of the road, is that when you asked him to step out of the vehicle?
Yes, sir.
And did you, when he stepped out of the vehicle, did you notice anything? Did you observe his appearance or his mannerisms or how he was acting when he stepped out of the vehicle?
Yes, sir. I noticed that he had the water, bloodshot eyes. The odor of alcohol was coming from him.
Did you observe him walk? Before? Did he have to say, what was his clothing? Did he look like disabled or?
If you classify somebody normal.
Did he say anything at that point?
When
Like it, and after he got out of the vehicle before you performed the field sobriety test, did he say anything else that you recall?
No, sir, I don't know.
Did you ask the defendant to perform the field sobriety test?
Yes, sir.
And what are these field sobriety tests used to determine?
To determine impairment.
Do they help determine if he can safely operate a vehicle?
Yes, sir.
If in this situation, if he had performed the field sobriety test and determined based on that performance that he was not impaired, in this instance, would you still been able to write him a ticket for driving under the influence of
Objection,
alcohol?
speculation, Judge. Those are not the facts of the case.
Answer if you can, please.
Can you please repeat the question?
So, if he had performed, if his performance in the field sobriety test showed that he was not impaired, would you have still wrote him a ticket for driving under the influence of alcohol?
No, sir.
So what field sobriety test did you perform? Just to listen.
Yes, sir. I asked him to perform the horizontal gaze and stagnance test, the walk and turn test, and the one-leg stand test.
Okay. We'll start with I'm probably going to butcher this, horizontal gaze and stagnance test.
Yes, sir.
You asked him to perform that test?
Yes, sir. The horizontal gaze is not existent.
I remember using this to determine the level of impairment.
Horizontal gaze is not admissible at a trial.
It is admissible if a sufficient foundation can be laid, but we're not to that point yet. So I think you just asked him, did he do it? So if he hadn't asked about any results, Mr. White, I'm sure at that time you can raise your objection.
Did you ask him to perform that test?
Yes, sir, I did.
And did you tell him what you were asking him to do?
Yes, sir.
Did you explain it to him? he indicate he understood the instructions?
Yes, sir.
Did you ask him if he had any injuries that would prevent him from taking that test?
Yes, sir.
Did he indicate any reason why he would not be able to perform that test?
Mr. Lowry stated he had stigmatism.
Does the stigmatism affect the HG?
Yes, sir. Objection, he's not a doctor, he's not an eye doctor, optometrist, he can't answer that question.
Unless you can lay some foundation, Mr. White, excuse me, Mr. Williams, to stay out of here.
Thank you.
No, y'all, we had to wait.
We don't know that.
We're not family. What kind of training, have you had training in performing the HGM?
Yes, sir.
Okay. What kind of training have you had?
I've had several 40 hours in the academy, and plus I've had advanced road impairment driving enforcement training.
Okay. And during that training, do they tell you whether certain things will affect whether or not you perform that test?
Objection, that's hearsay.
It's talking about his training.
You're getting into what people said, what people are telling you, that's hearsay.
Rephrase it, Mr. Williams.
Have you had training in determining whether certain things can affect the HG?
Yes, sir.
Have you had training in whether having an astigmatism can affect the results of an HG?
Yes, sir.
And in the course of that training, does an astigmatism affect an HG?
No, sir.
Did Mr. Lowry perform the test?
Yes, sir.
You tell the court how he performed the test.
Objection, foundation. Not complete.
Sustained.
Let's move on. What was the next test he performed?
The walk and turn test.
Did you tell the defendant what you were asking him to do?
Yes, sir.
Did you explain the test?
Yes, sir.
Did you demonstrate the test?
Yes, sir.
Did the defendant indicate he understood the instructions?
Yes, sir.
When you performed this test, you had to walk in a straight line?
Yes, sir.
Where on the road did he perform this test?
On the shoulder.
Okay. How did you establish a straight line?
I drew the line myself.
With your, in the dirt?
Yes, sir.
With your shoe?
Yes, sir.
Did you ask him if he had any injuries prohibiting him taking the test?
Yes, sir.
Did he indicate any reason why he should not be able to perform that test?
No, sir.
Did he attempt the test?
Yes, sir.
Let me ask you this. Did he say anything to you before he took the test?
I do not recall.
Did he question the line, the straightness of the line?
Yes, sir.
You tell the court how he performed the test.
Yes, sir. When asking Mr. Lowry to perform the walk and turn test, Mr. Lowry started too soon. Mr. Lowry wouldn't even let me explain the test before I even started. I asked Mr. Lowry to put his left foot on the line, put his right foot in front of his left foot, heel and toe. I asked him to stay in that position with his arms in a downward manner. Do not use them this way while I explain and demonstrate the test. I asked Mr. Lowry to take 9 heel-toe steps forward on the line. After the first 9 heel-toe steps, I asked him to keep his left foot planted, take a series of small steps with his right foot. I asked him to walk 9 more. Once I asked him to start the test, do not stop the test. I asked him to keep his hands down by his side, do not sway, and to look at his feet with his balance. He performed the test. He started too soon on the first set of steps. He missed steps 3, 6, and 7, and he stepped off lines
Judge,
on 4, 5, and 7.
I think the trooper is testifying to notes. We don't have those notes. We're entitled to those notes. Looks like he's reading from some notes. We don't have those. They were not produced to us in our request for discovery.
You, Mr. White, a question to.
I'd like to see them at least, Judge. I mean,
Get a copy.
that's a due process issue there to have all the discovery that they're going to use, and he is obviously reading from his notes or something that he's prepared for this trial.
Okay. Now, Mr. White would be entitled to a copy to the portion that the trooper is using to refresh his recollection. So,
I didn't notice it until he started looking down reading.
you will make Mr. White a copy of the notes to which Trooper Phelan will be referred.
I tell you, while he's doing that, Judge, I would like to make a motion for a mistrial, because we did not mention those. Due process requires that we receive a copy of everything they're going to use at trial. They produced us the machine test results, and the driving privileges affidavit, which is normal. We filed our request for discovery some months ago, and here we are at trial, and we don't have this document. And that is prejudicial to my client, to our client, Mr. Lowry. So we would move for a mistrial respectfully.
Your Honor, I'd like him to show where he actually filed a motion for discovery. But B, Your Honor, these notes we did not have until today. They were brought in by the trooper as he was preparing for this trial.
Judge.
So there's no way we would have known.
And also, Judge, we're not introducing his notes in evidence. And Mr. White is only entitled to what he did use to refresh his recollection. If the trooper needs more time we may need to take a recess so he can refresh his recollection and come back on the stand, but we're not intending on introducing it into evidence, so I don't think that there was any kind of
First of all, Judge.
violation.
First of all, Judge, Mr. Witt asked that I show him my request for discovery. Here's an official docket that was electronically filed on December the 9th, 2020, 11:12 a.m. in the 3 cases that are before the court, and it's a request for discovery. I think Mr. Witt will now acknowledge that we did indeed file that. And the second thing is, it's not an excuse if the district attorney doesn't have these notes in their file. If they're going to use it at trial, or it's going to be used at trial in any shape, form, or fashion, they got to produce it to us. That's standard constitutional due process, Judge.
Your Honor, we're not introducing these notes into court. They're not discovery. They're used for recollection of this trooper.
And they would be entitled to it if it had any kind of exculpatory material in it.
Well, how are we supposed to know if it's exculpatory if we don't have a copy of it?
Well, it's the state's right to determine whether or not it's
Not if you're going to use it on the witness stand. That is not the law. If you're going to use it on the witness stand, I'm entitled to a copy of it, whether it's got exculpatory in it or not. It's not for the state to determine that it's got exculpatory.
All right. Here's what we're going to do. We are scheduled to take a refreshment break at 10:45. And that clock seems to indicate it's about 10:35. Is that correct?
That's correct.
Okay. So what we are going to do is go ahead and take our refreshment break 10 minutes early. It's going to be for 15 minutes, but I need to instruct you, ladies and gentlemen, that we're going to have the bailiff escort you down to where the refreshments are. But you have not heard all of the evidence in this case yet. So you are instructed that you are not to discuss this case at this point amongst yourselves or with anyone else, or to allow anyone else to discuss the case with you or in your presence. We're not here yet. You haven't heard everything. So even you, 14, cannot discuss this case at this point amongst yourselves. And certainly do not listen to anyone who may want to try to discuss this case with you during recess. If anyone attempts to discuss this case with you, you have a duty to report that to me when you come back, and we will address that. So that includes attorneys, the parties, any witnesses, any family members. If anybody approaches you, you tell them the judge has instructed me not to discuss this case. Now, I'm not telling you can't talk to each other. Just don't talk to each other about this case. So, and in today's society, I also have to instruct you that you may have heard some terms that you're not familiar with yet. And you cannot do any independent research while y'all are out on break. All of you probably have a little computer in your pocket called a cell phone where you can Google or search the internet for different terms, but you are instructed not to do that. That is improper at this point. And with the technology today, any use of an electronic device such as your cell phone, smartphone, laptop, desktop, anything, email, text, Google, that's prohibited at this point. So you are instructed not to do that. You may feel the urge to, during break, to what you do nowadays, Snapchat, tweet, but you cannot do that at this point either. So you are not to communicate in any way about this case whatsoever, electronically or otherwise. Officer Barrett?
Yes, sir.
Are we ready?
Yes, sir.
Ready for recess?
Yes, sir.
So we're going to give them a 15-minute recess, and you will have them back in here in 15 minutes.
We'll take care of it.
Thank you. You may go with the state.
All right.
This way, folks.
Jacob's going.
freezing now.
Yes, sir.
Okay.
I did straight parts.
Yes, I ain't gonna
Well,
wait.
yeah, I have to left it with that.
You were not good at this today.
No, just say right.
I'm mad at you.
And then we'll play with you.
No, that's the way through. That's the original. The original came out of here. Could I get all the originals? Did you take any out of here? No, 11.
am not doing the case. Anyway, let's see Chris every day. Hi, Chris. I love it.
Go to the state office here.
Oh, thank you.
That's the loudest I've ever heard you talk.
I'm good at lunch.
Say nothing crazy.
I think I saw one outside earlier. I don't have one with me. Is there somewhere I should look here?
Rise.
Attorney, you ready to proceed? All right. Under advised of Mr. White's motion for mistrial, Mr. White then provided a copy with the notes that the officer was testifying to.
We have to.
Mr. White, I'm going to deny your motion for mistrial.
Yes, sir.
All right, Mr. Witt.
Let's begin back with the one-legged stand. Did you show him how to perform a one-legged stand?
Yes, sir.
You tell the jury how you perform a one-legged stand, how to perform a one-legged stand.
Yes, sir. I asked him to take, while I explained and demonstrated the test, to put his feet together, put his hands down by his side, don't move unless told to do so. I asked him to take it, either foot he wants, lifting approximately 6 inches off the ground, point his toe about it, told him to lift it as high as an hand can, reference to what he was drinking. Told him to point his toe, told him to keep both feet parallel to the ground to help you with his balance, told him to keep his hands down by his side to help with the balance, and look at his foot to help with his balance.
Okay. How did he do on that one?
He put his foot down 3 times. He had unsteady balance. He used his arms to sway, and he was hopping on 1 foot.
Okay. All right. And at that time, did you place him under arrest at that time and take him to jail?
After that, not at that time.
But did you take him to the Escambia County Jail?
Yes, sir.
Former Drager?
Yes, sir.
And that Drager is used to determine, how much blood alcohol content someone has?
Yes, sir.
Okay. And when you use that Drager, what did he blow up with?
He blew a .09.
And what's the legal limit in the state of Alabama?
.08.
Move to admit State Exhibit 1 into evidence, which is the
No objection, Judge, stick to
Exhibit 1 is in evidence.
Okay, did you have a body cam on at this time?
Yes, sir.
Okay, and, that, body cam was working properly?
Yes, sir.
And, have you had time to view the, body cam footage that was transferred to the flash drive?
Yes, sir.
Okay. And is that footage on that, as it was that day, not been altered?
Yes, sir.
We'd like to move to, admit State Exhibit 2 and, play the video for the
Stipulate.
Exhibit 2 is in evidence. First made exhibit to the trigger. Turn off the lights over there.
So we know sound started.
Yeah, I smell it right there. Yeah. Oh, yeah, I knew it right then. Hey, man, I see you had a few 2 natural lights on the back. Is that cooler full of beer?
Yes, sir.
All right, go ahead and step on that one. Okay. And you got a container?
Yes, sir.
Come on back. Where do you work at, man?
GP.
Man, ain't you going to work?
No, sir, I'm going to the house.
Okay. All right, I got you. Do you know your social security number?
Yes, sir.
What's that? Your name?
Jason Lowry. Buford Jason Lowry.
You ain't in the Derek Lowry, man?
I don't think so.
Okay, I got you. So what we're going to do is, and you're going to have 2 tonight, right?
Yes, sir.
Okay, you kind of groggy with me a little bit, so you probably have.
You got me nervous, man.
Well, yeah, man, I mean, you've been drinking, you ain't got all those things.
I'm good.
I'd be nervous too.
Well,
Because I'm not good
I was just talking to somebody on the phone, and I'm kind of good.
All right, so come on, let's go on over here, okay? I'm going to do some Phil's Fridays, okay? All right, let's get away from that, okay? Get away from the whole lot. Let's look away from them, okay? Look towards me this way. All right, put your feet together. Hands down by your side. Yes, don't do less on this, okay? Take your hat off, put it to the side. So I said it doesn't get any way. All right. So I want you to put your hands down by your side. Okay, well, if you only have a couple, then it shouldn't affect too much of the way you drive. All right, but if you have more than that, I'll be able to tell. I'll let you know, okay? Feet together, hands down by your side, don't do less on this, okay? So I want you to just follow the tip of my finger with your eyes and eyes on it, okay? Don't do anything, do you understand? You don't have no distractions or anything?
Sorry?
You don't have no distractions or anything?
What's that mean?
Alright, then if you don't know what it means,
Hold on, what did you say?
I asked you if you had any kind of eye problems or distractions.
No, sir, I mean, I've got astigmatism.
Oh, that's fine, that ain't gonna affect you looking at this finger, okay? Follow tip of my finger, your eyes on it, okay? About it.
Well, I'm watching your phone.
Okay, that's right.
Yes, sir.
Did you tell him this
myself.
Okay.
I mean,
I got you. All right, man. So come on over here. Let's make us a line, all right? See that line I just made? No, oh no, that was a straight line, my friend. You the one that think. See that line? It's the same line. All right. It's right there, all right? I see. All right. So put that left foot on that line. And right foot in front of your left foot. You're going to take just like this. Take just like that. Keep your hands down by your side. I haven't told you to move or anything. All I've instructed you to do is put your left foot on the line, put your right foot in front of your left foot, heel to toe, and stay in that position while I explain and demonstrate the test, okay? Just like that, okay? Alright, so what you're going to do is when I tell you to begin, okay? You're going to take 9 heel to toe steps that way and 9 back. So you're going to count out loud after each step. You're going to keep your hands down by your side. You'll start to heavy where you balance, start using the sway. You're going to look down at your feet and where you balance, okay? Alright? Once you start the test, do not stop the test, okay? Once you get to your first 9, you're going to go 1, 2, all the way to 9, okay? You're going to keep your left foot planted. Take your right foot, like a series of small steps to turn around, and walk. 9 more back. Count out loud, hands down by your side. Look down at your feet and head where you balance, okay? Any other questions?
Yes, sir.
Alright, you may begin.
Ready? 2, 3, 4, 5, 6, 7,
Okay. Yeah.
Is that good?
Yeah. Go ahead and put your feet together. Hands down by your side.
Yes, sir.
Don't move unless don't do so, okay? Next is called a one-leg stand, okay? You don't choose any foot you want. You're going to lift it approximately 6 inches off the ground. About like a natural light can, just like that, okay? You lift it up about a beer can, all right? You're going to keep both feet parallel to the ground. You're going to look down at your feet and where you balance, okay? You're going to keep your hands down by your side, like in a walk and turn, and where you balance on using the sway. You're going to look down at your feet, like in a walk and turn, okay? You're going to count out loud our feet. 1001, 1002, 1003, 1004, and so on until I tell you to stop. Okay, do you understand?
Yes, sir.
All right, any foot you want. Go ahead. You may begin.
2, 3.
I ask you to continue until I tell you to stop. All right.
3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. I mean, you're trying to get
No, sir. Are you done?
No, sir.
Okay. Do you want to start back over? Okay. I just asked you to just continue doing it until I tell you to stop. I told you to keep counting until I tell you. Just stop. You feel like you're done?
No, sir.
Okay. All right. Hey, you stop, okay? And how long ago was it that you drank? How long, sir?
Trevor Elam, is it, based on your experience, was based on the testimony you gave and the video, was Jason Lowry impaired, point of not being able to safely operate a vehicle.
Yes, sir.
And do you ever seatbelt on?
No, sir.
Nothing further, Your Honor.
Please go ahead. Mr. White, you may cross examine. Officer, you stated that on your notes here that we just got a copy of that Mr. Lowry was hopping.
Yes, sir.
I didn't see that on that video. Was it on that video when you were giving the test?
Yes, sir.
What part? Because I didn't see it, that he was hopping.
On the third test, when he went to put his foot up, he hopped. Also, whenever on the second test.
So it's, whatever that shows, it shows.
Yes, sir.
And you said he was swaying. I didn't see that on the test either.
Yes, sir.
You're saying it was on there, so it speaks for itself.
Yes,
We
sir.
just saw it. And he asked you after, one of the tests was that good, after the walk line, where he went 9 steps up, turned around, and come back. You said, was that, he said, was that good? And you said, yeah. You remember that?
Yes, sir.
That was on the video,
Yes, sir.
correct? And on the one-leg stand, your notes say, it tells what you instructed him to do. And on here, it says he was to keep his legs straight and count out loud 1,001, 1,002, etc., and so forth until instructed to stop after 30 seconds. You know that's in your notes?
Yes, sir.
You didn't tell him to stand there 30 seconds, did you? Yes or no?
No.
So what's in this, your notes is not true, is it?
Objection, Your Honor, the notes aren't in evidence.
It doesn't matter, I got him on cross, Judge, he was referring to his notes.
What was the question? Could you please repeat?
You read it back.
So what's in the notes isn't true, is it?
So what's in your notes here, where it says 30 seconds, is not true. You didn't tell him that, did you?
I did not tell him to stand for 30 seconds.
Okay, but your notes say you did.
Those are my notes. Do you understand my writing?
Excuse me?
Do you know how I speak or how I write?
I'm just going by what is written down. These are the notes you were testifying from, true. And it says here that it instructed to stop after 30 seconds. I didn't hear that. Now you're telling me you didn't tell him that. Did you tell him 30 seconds or not?
No, sir.
Okay. And you talk about here the walk and turn. It says the results of this test displayed 4 of 8 possible clues. But the other 4, he was clean, wasn't he, of the clues? Yes or no?
Is that a question?
Yes.
Could you please repeat?
On your notes, you say the results of the walk and turn test displayed 4 of the 8 possible clues. Only 4. The other 4 he would have been okay on, correct? Yes or no?
If he would.
Yes or no?
No.
He would not? Well, why didn't you put anything else about the other 4?
I don't understand your question.
Well, you said there's 8 possible clues from the walk and turn test, right?
Yes, sir.
And it looked to me like you did perfect on the walk and turn test. I didn't see any flaws. Did you? Did you see any flaws on there?
Yes, sir.
Now, when you told him you wanted him to do the walk and turn test, you reached over there and dragged the line with your shoe in the dirt, correct?
Yes, sir.
Is that standard operating procedure, Trooper?
That was the safest location.
Is that the standard operating procedure, yes or no?
Yes.
For you to draw a line in the dirt on the side of the road for a person to walk a line on?
The standard is wherever.
Let me ask you, that's a yes or no question, okay? That's a yes or no question.
Yes, sir.
Is that standard operating procedure for you to draw a line with the heel or side of your shoe to give a walk a line test? Yes or no?
Yes.
Now, when you drug your foot down on the dirt, it created a little crevice, didn't it? To make a line.
Yes.
And you asked him to walk in that crevice, heel to toe, correct?
Yes, sir.
And that video speaks for itself, don't it?
Yes, sir.
And you gave this test on the side of the road with blue lights going, correct?
Yes, sir.
Your blue lights were going. There were other blue lights going, weren't there?
Yes, sir.
How many different cars with blue lights on were going when you gave these tests on the side of the road?
Two.
Two state troopers, or was it a deputy or a
Yeah, county deputy.
county deputy? Okay. So we saw the blue lights flashing on the video, right?
Yes, sir.
Did you have your takedown lights on?
No, sir.
Did you have your headlights on?
Yes, sir.
Okay. So did the other car, law enforcement car, have lights on, if you remember?
Yes, sir.
So we got two sets of blue lights, two sets of headlights on the side of the road is where you gave this test.
Yes, sir.
And he was within a mile of his house.
Objection, he's made a statement, not asking a question.
Was he within a mile of his house?
I did not.
Did he tell you he was within a mile of his house?
Yes, sir.
Okay. And were cars passing by at that intersection where y'all had this stop at?
Yes, sir.
Why did you put him over on the edge of the road where there's a line? Actual line.
The roadway is a non-safe location.
Okay. So you think on the side of the road, that's right. How far on the side of the road were you? 5 feet?
I do not recall.
You don't remember how far you were off the main highway when you drew that line with your foot?
I don't have a tape measure.
Give me your best estimate, officer.
Approximately 15 feet.
15 feet?
Yes, sir.
Okay. If that shows different, it speaks for itself, don't it?
You said give approximately.
Well, I
With
think
my
you went
guess.
on the high side, didn't you, officer, to try to help the case?
No, sir.
You wrote this ticket, you wrote all these tickets, didn't you?
Yes, sir.
And you went and took him down to Brewton, I suppose Brewton, and you gave a test, didn't you?
Yes, sir.
Why didn't you get somebody neutral to give the test that didn't write the tickets?
Objection, Your Honor. That's totally not how the procedure works.
Judge, it happens like that all the time. He can answer that question.
I'm not saying that objection as to how it's phrased.
You gave the test even though you wrote the ticket, right?
Yes, sir.
Isn't it sometimes the practice of law enforcement, whether it's deputies, if you know, state troopers, city police, that the person that writes the ticket has someone else give the intoxilizer or the Drager test?
Someone.
Objection, Your Honor. We're not here to determine what happens in other cases. We're here to determine what happened in this case.
Oh, you can answer, yes or no.
Repeat the question, please.
Are there occasions when the trooper or policeman, deputy that writes the ticket, that a second officer gives the test at the location?
No.
That never happens, officer? Are you sure? You're under oath now.
If I'm certified
My
to
question is, you're telling me under oath that that does not happen? That's what you just said, right?
I can't speak for nobody else. As far as me, no.
Don't you think that's a little prejudicial because you're trying to get him to run over a .08, aren't you?
No, sir.
You said that he had slurred speech.
Yes, sir.
Did you say that video shows that? You could tell that he had slurred speech? Yes or no?
Yes.
And we didn't see anything about any watery eyes, bloodshot eyes, or anything on that video, did we?
No, sir.
Now, this was a roadblock, right?
Safety checkpoint.
What we call a roadblock.
No, sir. Safety checkpoint.
What do you call a roadblock then?
A roadblock is whenever somebody's blocking the roadway for nobody to pass by. This is a safety checkpoint.
You've never heard it called when policemen are out in a rural area like this where they set up, that's called a roadblock?
Objection, asked and answered. He asked him about what a roadblock was.
I got him on cross-examination, Judge.
Answer if you can.
No, sir.
Have you been a trooper how long? 3 years?
Yes, sir.
Now, you never observed this man drive driving, did you, other than him pulling through the safety check, correct?
Yes, sir.
He stopped when you stopped him, didn't you?
Yes, sir.
You told him to pull off the side of the road, correct?
Yes, sir.
He pulled off the side of the road, correct?
Yes, sir.
Did you notice anything erratic about his driving when he pulled off the road?
No, sir.
Okay. And this is not a case where you observed him driving and swerving on the roadway?
No, sir.
No erratic driving by him crossing the center line?
No, sir.
No erratic driving by him running off the road into the ditch?
No, sir.
Nothing erratic about his driving that you observed and can testify to, correct?
Correct.
You're going strict to start there. And did you say he did not show you his driver's license?
No, sir.
You didn't write him a ticket for that, did you?
No, sir.
You said he did not show you any insurance, or did you say he did?
I do not recall.
You didn't write him a ticket for that, did you?
No, sir.
Did he tell you he could come from his hunting camp,
I do not recall.
which was right up the road?
Do not recall.
You don't recall him telling you?
Asked and answered, Your Honor.
You put it in your notes?
I do not recall.
Why didn't you recall? You just recalled all these other details, that he hopped and he swayed and he did this and did that. You
Your
can't
Honor,
tell
you
me what he
can't
goes.
testify while you don't remember
I do not recall.
Is that what they taught you to say at trooper camp? I do
No,
not
sir.
recall.
No, sir.
Well, where did you learn that from?
Objection, Your Honor, it's not relevant.
It is relevant, Judge. Because that's all he's given me. I do not recall. I do not recall. I do not recall. I'll move on, Judge. I'll move on.
Thank you, Mr. White.
Yes, sir. Now, you said he had beer on the back of the truck?
Yes, sir.
Not against the law to do that, is it?
No, sir.
Actually, it's not against the law to have a beer or two and drive, is it?
No, sir.
So if we believe what this man told you that night, he was not violating the law, correct?
No.
And then this jury should find him not guilty, correct?
No.
Is that right or not?
Do not recall. Could you please repeat the question?
Mr. Prosecutor, here, Joe Witt from the DA's office asked you how he was dressed, and you said normal.
If you classify normal, normal.
What does that mean?
Daily attire, what someone wears.
Okay. He wasn't disheveled, buttons unbuttoned, or buttoned up crooked, or nasty, or anything like that, was he?
No, sir.
Officer, this machine test that y'all put into evidence, the state put into evidence, you understand and I understand that this machine does not test a person's ability to drive safely, correct?
No, sir.
All it does is gives you what it sees as the blood alcohol content.
Yes, sir.
Okay. And this test results only raises the presumption that it was under the influence. You understand that, or do you know that legal principle? You may not know.
What's the question?
Did you know that this reading, .09, which is 1 point over 0.08, just raises a presumption of driving under the influence?
Could you define presumption?
Okay, so you don't understand. Okay, I won't confuse you, okay? I noticed you did not check the check box on the driving privileges affidavit, difficulty following instructions. You didn't have any difficulty following instructions, did you?
No, sir.
You didn't strike impaired memory either, correct?
Correct.
Okay. And you say he was cooperative.
Yes, sir.
He did not say, I'm not going to take any tests, did he?
Correct.
He did not turn around and try to run from the safety check.
Correct.
Those are my questions, sir. All right, thank you, officer.
Read it. Okay. All right. Trooper, you may step down. See excused. Okay. Mr. White. Trooper excused.
He is excused, yes, thank you.
Trooper, you may remain in the courtroom, or you're free to go. You need to be somewhere. How are you next witness, Steve?
State arrest.
All right. Ladies and gentlemen, the state has arrested, so you've heard the state's case. Mr. or Ms. White?
Both judges, little judge, both states.
Denied.
Yes. We will call.
Mr. Buford Lowry.
All right. Mr. Lowry. Ladies and gentlemen of the jury, this is the presentation of the defendant's case. Mr. Lowry, if you'll stop right there, raise your right hand. You swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God. Yes, sir. Mr. Lowry, if you'll have a seat. And just so you can speak into that microphone for us, please. Ms. White,
Thank
you
you.
witness this morning.
Thank you. State your name for the record, please.
So, Buford Jason Lowry.
And where do you live?
I live on 251 South Baggett Circle, Brewton, Alabama.
And how long, are you a native of Brewton?
Yes, ma'am.
Okay. Are you married?
Yes, ma'am.
Who's your wife?
Christine Lowry.
You have kids?
3 kids.
Where do they go to school?
T.O.
They all are local people, huh?
Yes, ma'am.
Where are you employed?
Yes.
Where at?
Georgia Pacific,
For how long?
11 years.
Do you do any sort of stuff around the community? You coach any teams?
No, ma'am, I don't.
What do you do for fun?
Hunting and fishing.
That's good. All right, I want to take you to this night that we've been talking about. Where had you been before you came up on this roadblock?
We were working on our hunting club,
Okay, and how far is that from your house?
approximately a mile.
Is that on a dirt road, I guess?
Yes.
And did you see the roadblock before you came up on it?
Yes, I did.
Could you have turned around if you wanted to?
No, ma'am.
Let me back up. Had you had anything to drink at the hunting camp?
Yes.
What did you have to drink?
Couple of natty lights.
So you come up on the roadblock, and the Officer Elam come up to your window?
Yes, ma'am.
Okay. Were you wearing your seatbelt?
I was before I noticed that it was the roadblock ahead. So I unbuckled, trying to find my wallet, making sure and apparently I had not had it, the wallet with me, so,
Why didn't you have your wallet with you?
because I was working on the hunting club and just didn't put it in my pants.
Because you were only a mile away?
That's right. Didn't want to lose it or, get it all sweaty while we were working.
When you were driving from the hunting club to the roadblock, did you feel that your driving was impaired at all?
No, ma'am.
Do you remember if you drove off the road at all?
I did not.
Or swerved at all?
No, ma'am.
So you get to the roadblock, Officer Elam, he asks you for your wallet. When did he ask you to get out of the car?
He didn't ask me to get out of the car until he told me to pull over to the side.
Did you have any trouble pulling over?
No, ma'am.
And getting out of the car, did you have any trouble?
No, ma'am.
Do you remember if you stumbled?
Stood fairly well.
of that night clear?
Yes, ma'am.
You heard Officer Elam testify about the sobriety tests he gave you. The walk and turn, you drew a line in the dirt with the shoe. Could you see the line?
Yes, ma'am.
Okay, how do you feel you did on that test?
I felt fairly good as far as walking in the dirt, heel to toe.
Did you stumble at all?
I don't feel like I did.
And then what about the one-leg stand? How do you feel you did on that?
I felt good about the one-leg stand. You know, I didn't know I had to count a minute, you know.
You got up to, I think, was it 18 or 19?
I believe it was 1,018.
And you didn't know when to stop, right?
Yes, ma'am.
Tell me about your driving record. When's the last time you had a ticket, if you remember?
It was 1995.
That 95 is the last time you had a ticket?
Yes, ma'am.
Wow, do you remember what it was for?
No seatbelt.
And other than that, clear driving record for the last 25 years?
That's correct.
Okay. When you were pulled over on the side of the road, were you scared?
Yes. Blue lights tend to make you nervous.
Mm-hmm. Were you worried because you had neighbors driving down the street, or maybe your wife?
Yeah.
Had you ever been to jail before that?
No, ma'am.
That was an experience too then, wasn't it?
Yes.
So do you feel that your driving was impaired that night?
No, ma'am.
Do you know when you've had too much to drink to drive?
Yes, ma'am.
So you're aware of when you're at that level of intoxication?
Objection, he's not a trained law enforcement officer.
Judge, he's a grown man who has experience with drinking beer and knows his level of intoxication. He can certainly testify to that about himself.
Okay, I think he's answered, but sustain the objection as to any further questioning on this.
Yes, Judge, I'll move on. Might be all I have. Let me confer with my co-counsel. My father. That's all we have at this time, Judge.
Cross-examination.
Just a couple quick questions. Mr. Lowry, you tell them the truth today?
Yes, sir.
You stated in 1995 you had a seatbelt ticket.
I believe that's correct.
Isn't it true that you had a speeding ticket in 1995?
Yes.
So you didn't tell the truth about that?
Well, that's how many years ago now? That's kind of foggy.
So if you didn't tell the truth about that, how do we know that you told the truth about anything else?
I don't know.
No further questions.
That's all we have, Judge. Thank you, Miss.
Larry, you may step down.
Thank you.
Okay, ladies and gentlemen of the jury, the defense is rested, so the state have any rebuttal?
No,
All right, so we're prepared to go to closing arguments.
Yes.
All right, you'll adjust the podium for us. Ladies and gentlemen, you've heard the evidence, the attorneys are going to have the opportunity to come to you in what's called closing arguments and explain to you what the evidence, in their opinion, has shown. At this point, they're allowed to make reasonable arguments and inferences from the evidence. If you're ready, Mr. Wood.
Ladies and gentlemen, I believe we've proved beyond a reasonable doubt that Jason Lowry was driving under the influence of alcohol, that he had an open container, and that he was not wearing a seatbelt. You heard the evidence that was presented today. picture yourself driving on a road, 8 o'clock at night. You've left your boyfriend, girlfriend's house, you left work, you left your parents' house to go somewhere, and you've approached a drunk driver on the road. And that drunk driver is in your lane. Just think about what could happen. You're honor bound, based on the evidence presented, to find Jason Lowry guilty of driving under the influence of alcohol, having an open container of alcohol, and not wearing a seatbelt. Thank you.
As I said at the beginning, it's innocent until proven guilty. The state had to prove to you today that Mr. Lowry was driving under the influence of alcohol. And as I explained earlier, what that means is that a person is so impaired that their ability to drive is impaired by the alcohol. They consume so much alcohol that they cannot drive safely. Of course you wouldn't want to approach a drunk driver in your lane late at night, but that was not Mr. Lowry. The evidence showed today that he was not driving erratically. The evidence showed that he did not cross any of the lines on the road. He was perfectly fine driving. You saw the videos. You saw him walk the line in the dirt with the rocks and the gravel and the sticks, and he did a pretty good job. You saw him stand on one leg for, he didn't know for how long. He had to sit there forever and stand on one leg. Also did a pretty good job. It's kind of hard to stand on one leg if you don't do that often. So I don't think the state has met their burden today. And it's the state's burden. They have to prove to you, beyond a reasonable doubt, it's just a reasonable doubt, that he was driving under the influence of alcohol. And they have not met that burden, and you should find Mr. Lowry not guilty. Thank you.
For a vote?
Brief, Your Honor. Ladies and gentlemen, no one saw Mr. Lowry until he pulled up to the roadblock. So no one knows whether or not he was crossing lanes, driving in the wrong lane, all over the road. We don't know how many near misses he might have had before he got to the roadblock. But what we do know is that he blew a .09 on the Drager, which is above the legal limit. It's considered driving under the influence.
You have the attorney's approach. Okay, ladies and gentlemen, you've heard all of the evidence in this case and the arguments of the attorneys for the state and the defense. And they've done an able job in representing their clients this morning. It's now my job as judge, or what we call the court, to tell you what the law is, so you can apply the facts to the law. You're not expected to know the law. You are not learned in the law. So it's my job now
to try to explain it to you so you can apply it to the facts that you are going to determine. You should not think from anything that I tell you now or in any way that I have ruled throughout this case that I'm trying to express an opinion about the facts. I have no opinion about the facts because you are the sole judges of the facts of this case. You are to take the law as I explain it to you and apply it to the facts as you determine them to be. And by doing that, you will arrive at a verdict in this case. Sympathy or emotion are not elements of evidence and must not be allowed to influence you in your consideration of the evidence. At this time, it's my duty and privilege to instruct you on the law as it applies in this case. As we talked about earlier, Mr. Lowry is charged by way of complaint with the offense of driving under the influence of alcohol. And it alleges that on November 5th of 2020 that Mr. Lowry did unlawfully operate a motor vehicle or other vehicle at or near Appleton Road within the county of Escambia, at or near Mason Mill Pond Road, in violation of section 32-5A-191A2 of the Code of Alabama. Again, that's called the offense of driving under the influence of alcohol. He's also been charged with failure to wear a safety belt, which is by way of complaint that alleges on November 5th of 2020 that Hubert Jason Lowry did unlawfully operate a motor vehicle or other vehicle at or near Appleton Road within the county of Escambia, at or near Mason Mill Pond Road, in violation of section 32-5B-4 of the Code of Alabama. And that is an offense referred to as failure to wear a safety or seat belt. Mr. Lowry is also charged by way of complaint with the offense of open container violation. And that complaint alleges that Mr. Lowry did on November 5th of 2020 unlawfully operate a motor vehicle or other vehicle at or near Appleton Road within the county of Escambia, at or near Mason Mill Pond Road, in violation of section 32-5A-330 of the Code of Alabama. Again, that's an open container violation. Now, the mere fact that Mr. Lowry has been charged is not evidence in this case. The charges are merely the formal method under our Constitution by which a defendant is accused of a crime placed on trial. The complaints themselves provide no proof, nor any presumption, nor any inference that Mr. Lowry is guilty of the offenses charged therein. As to these complaints, Mr. Lowry has entered pleas of not guilty. He says that he is not guilty of any charge contained in the complaints. Under our system of justice, a defendant is presumed to be innocent of a crime. That means that a defendant, although he has been accused, begins the trial with a clean slate, with no evidence against him. The law permits nothing but legal evidence presented before the jury to be considered in support of any charge against the accused. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt from all of the evidence in this case. Now, the state of Alabama has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the case. The defendant is not required to prove his innocence. As I've already told you, the burden is upon the state to prove the defendant guilty as charged. Before a conviction can be had in this case, the state must satisfy each and every member of the jury
of the defendant's guilt beyond a reasonable doubt. Even if the state demonstrates a probability of guilt, if it does not establish guilt beyond a reasonable doubt, you must acquit the defendant. The phrase reasonable doubt is self-explanatory. It is not a mere possible doubt, because everything relating to human affairs is open to some possible or imaginary doubt. A reasonable doubt is a doubt of a fair-minded juror, honestly seeking the truth after careful and impartial consideration of all of the evidence in the case. It is a doubt based upon reason and common sense. It does not mean a vague or arbitrary notion. It is an actual doubt based upon the evidence, a lack of evidence, a conflict in the evidence, or a combination thereof. It is a doubt that remains after going over in your minds the entire case and giving consideration to all of the testimony. It is distinguished from a doubt arising from a mere possibility, from bare imagination, or a fanciful conjecture. If after considering all of the evidence you are convinced of the defendant's guilt beyond a reasonable doubt, then it would be your duty to convict the defendant. However, if after considering all of the evidence you still have a reasonable doubt, then the defendant is entitled to the benefit of that reasonable doubt, and you should acquit him. Now, ladies and gentlemen of the jury, it is improper for you to be concerned with what any penalty may be imposed in this case. That is a job for the court should you find Mr. Lowry guilty of any of the offenses. Your job is to decide whether he is guilty or not guilty based upon the evidence. The court would later determine whatever punishment, if any, should you find him guilty. In determining what the true facts are in this case, you are limited to the evidence which has been presented from the witness stand, as opposed to the matters which have been stated to you by the lawyers during the course of the trial. What the lawyers have said, both for the state of Alabama and for the defendant, is not evidence in this case. What they have argued to you at various times in the trial is not evidence in this case. They have a right and they have a duty at the appropriate time in the trial to comment on the evidence and to draw reasonable inferences from the evidence as they argue their respective positions to you. What they say is not evidence, however, and you should put what they say in the proper category of your thinking, and it should not be in the evidence category. Now, as to the specific charges, Mr. Lowry is charged with the crime of driving under the influence of alcohol. A person commits the crime of driving under the influence if he drives or is in actual physical control of any vehicle while under the influence of alcohol to a degree which renders him unable to drive his vehicle in a safe manner. To convict, the state must prove beyond a reasonable doubt each of the following elements of driving under the influence. First, that the defendant was driving or in actual physical control of a vehicle at the time. Second, that the defendant was under the influence of alcohol at that time. And that the defendant was intoxicated to the extent that he was unable to drive his vehicle in a safe manner. Now, actual physical control is defined as the exclusive physical power and present ability to operate, move, park, or direct whatever use or non-use is to be made of the motor vehicle at the moment. If you find from the evidence that the state has proved beyond a reasonable doubt each of the above elements, each of those elements, then you shall find the defendant guilty of driving under the influence. If you find that the state state has failed to prove beyond a reasonable doubt any one or more of the elements of the offense of driving under the influence, then you cannot find the defendant guilty of driving under the influence. Law on wearing a safety belt is that each occupant of a passenger car manufactured with safety belts in compliance with the Federal Motor Vehicle Safety Standard, number 208, shall have a safety belt properly fastened about his or her body at all times when the vehicle is in motion. This does not apply to a child passenger under the purview of Section 32-5-222, who is required to use a child passenger restraint system. Does not apply to an occupant of a passenger car who possesses a written statement from a licensed physician that he or she is unable, for medical reasons, to wear a safety belt. It does not apply to a rural letter carrier of the United States Post Office, or a driver or passenger delivering newspapers or mail from house to house. Or it does not apply to passengers in a passenger car with a model year prior to 1965. Or to passengers in motor vehicles which normally operate in reverse. So, ladies and gentlemen, if you find from the elements that from the evidence that Mr. Lowry was an occupant of a passenger car that has a proper safety belt and that it was not fastened about his body at all times when the vehicle is in motion, then you shall find him guilty of the charge of failure to wear a safety belt. If you find that the state has not proven one or more of those elements, then you cannot find Mr. Lowry guilty of the charge of failure to wear a safety belt. As to the open container, it is unlawful for a person to have in his or her possession alcoholic beverages in an open container in the passenger area of a motor vehicle of any kind on a public highway or right-of-way of a public highway in the state. An open container is defined as a container which is other than in the manufacturer's sealed condition. So, ladies and gentlemen, if you find from the evidence, that the state has proven each and every element of the crime of open container violation beyond a reasonable doubt, then you should find Mr. Lowry guilty of that charge. If you find that the state has not proven one or more of those elements, then you cannot find Mr. Lowry guilty of that charge. At this time, I'm going to read you requested charges, which are correct statements of law. I charge you, members of the jury, that you may reject the breath alcohol analysis, the results of any field sobriety test, or any other evidence in this case. I charge you, members of the jury, that you are not required to accept the results of the blood alcohol test as conclusive evidence that the defendant was driving under the influence of alcohol. I charge you, members of the jury, that the decision about whether the defendant is guilty or not guilty is in the hands of you, the jury, and not in the hands of the police officer who made the arrest. I charge you, members of the jury, that the consumption of one or more alcoholic beverages would not, by itself, be sufficient to establish the fact of intoxication. The evidence must go further and show facts indicating a mental condition that is not normal and that is produced or brought on by the alcoholic beverage. I charge you, members of the jury, that mere testimony by the officer that he smelled alcohol on the breath of Buford Lowry is not sufficient to support a conviction for driving under the influence. I charge you, members of the jury, that the results of the Draeger do not prove guilt beyond a reasonable doubt. I charge you, members of the jury, that the Draeger machine tests only blood alcohol content. It does not test a person's ability to operate a motor vehicle. Ladies and gentlemen of the jury, there have been witnesses who have testified in the trial of this case. Take the testimony of these witnesses together with all proper and reasonable inferences therefrom. Apply your common sense, and in an honest and impartial way, determine what you believe to be the truth. You should weigh all of the evidence and reconcile it if possible. But if there be irreconcilable conflict in the evidence, you ought to take that evidence which you think is worthy of credit and give it such weight as you think it is entitled to. You may take into consideration any interest that any witness might have in the outcome of this case. You are the sole judges of the evidence and of the credibility of witnesses. You may accept or reject any part of testimony of any witness, and you should accept only the testimony that you consider worthy of belief. In determining the weight to be accorded to the testimony of any witness, you may consider the demeanor of that witness while on the witness stand, his or her apparent candor or evasiveness, or the existence or non-existence of any bias or interest. Now, I charge you that if you believe any material part of the testimony of any witness was willfully false, you may disregard all of the testimony of that witness. In this case, the defendant, Mr. Lowry, has testified. He has a right and may testify as a witness on his or her own behalf. And when he does, you may consider the testimony of the defendant along with all of the other evidence in light of the fact that he is the defendant and interest which he has in the verdict. This is to be taken into consideration together with all other evidence or lack of evidence. Ladies and gentlemen, for the convenience of you, the court has prepared for your use in this case verdict forms which will be explained to you. Now, you should draw no inference from the fact that the court has supplied you with these forms or from the order in which the court reads them to you. When you reach a verdict, you will select and complete the appropriate form which corresponds to your verdict and which is to be signed by your foreperson. The first complaint charges the offense of driving under the influence. You must consider the evidence as to this charge, and you must determine whether the defendant has been proven guilty of this offense charge beyond a reasonable doubt. If you find from your consideration of all the evidence that the state has proven each of the necessary elements of the offense charge beyond a reasonable doubt, then your verdict should read, we the jury find the defendant guilty of driving under the influence. If, on the other hand, from consideration of the evidence or lack of evidence, you are not convinced that the state of Alabama has proven each of the elements of driving under the influence beyond a reasonable doubt, then you must find the defendant not guilty. And the form of your verdict would be, we the jury find the defendant not guilty of driving under the influence. Once you've made your decision, one of your members will sign one of the verdicts as foreperson. And we have prepared verdicts for each of the charges. So if you find from the evidence that the state has met its burden on the failure to wear a safety belt charge, then you should return the verdict form that says, we, the jury, find the defendant guilty of failure to wear a safety belt. If, however, you find that the state has not met its burden and it has failed to prove one or more of those elements, then you should return the verdict form that reads, "We, the jury, found the defendant not guilty of failure to wear a safety belt." And finally, we have a verdict form that reads, "We, the jury, find the defendant guilty of open container violation." So if you find that the state has proven all of the elements of the offense of open container violation beyond reasonable doubt, that would be the verdict form that you will return. If, however, you find that the state has not met its burden, then you would return the verdict form that reads, "We, the jury, find the defendant not guilty of open container violation." So, that can be confusing. So once you get back there, you're going to have to deliberate on the charge of driving under the influence, and you'll make a decision whether to find them guilty or not guilty based upon the evidence. If you find him guilty, you sign the guilty form for driving under the influence. If you decide to find not guilty, you only execute the not guilty form. So we get one form back for driving under the influence. The same with the other two charges. So when we come back, we will have only 3 executed verdict forms. One for the offense of driving under the influence, one for failure to maintain or wear a safety belt, and the third for open container violation. Ladies and gentlemen of the jury, all 12 of you must agree before you can reach any verdict in this case. Your verdict must be the verdict of each and every juror. You are the sole judges as to the weight that should be given to all of the testimony that you've heard in this case. The judge's duty is to decide the law. The jury's duty is to determine the facts. I have no opinion as to the facts in this case, and I don't want you to think from anything that I've said in this charge, or from any ruling I've made in this case, or by anything I've done in this case, that I think one way or other about the facts of this case, because I do not. Ladies and gentlemen, when you reach the verdict, you will complete, as we've discussed, one verdict form for each charge. And your foreperson will sign each of those forms. When the verdict has been completed, it will be necessary for you to return to the court and give your verdict. In the meantime, until you reach your verdict and until the verdict has been received and you have been discharged, it is absolutely necessary that you stay together and that you not for a moment separate while you're deliberating. If you need to take a break during your deliberations, you need to let the bailiff know that while you're on break, you are not to deliberate. You are only to deliberate when you are in the room together with all 12 of them. Ladies and gentlemen, during your deliberations, you will have with you the verdict forms that I have reviewed, along with any exhibits or documents that were introduced into evidence. I suggest to you, members of the jury, that the first thing that you do upon retiring to the jury room is to select a foreperson to help govern your deliberations and help ensure that things run in an orderly fashion. This is only a suggestion, and you are certainly free to conduct your deliberations in any manner that you desire. Once you have reached a verdict, please let our bailiff know that you have reached a verdict. You will then be called back into court in this courtroom to give your verdict. What says the state to the court's oral charge? Defense? At this time, we have 2 alternates, and I need to ask the alternates to remain here in the courtroom. We have alternates in case something happens during the trials. Should one of you get sick, then we might need to have an alternate stay and deliberate, but because that has not happened, the alternates are but alternate jurors are vital to our jury system here in the state of Alabama, so we appreciate your attendance. Now, when you get back to the jury room to start your deliberations, you will be in charge of what takes place after that. You decide whether you want to take a break or whether you're going to deliberate. If you have a question, you should have your foreperson write down the question, hand it to the bailiff, and the bailiff will bring it to the court. And at that time, I will decide whether or not we need to bring you back into the courtroom to discuss that question or other information. Our alternates are Samantha Borkins and Ruby or Rubai Nix. We're going to ask that you remain here in the courtroom, and the remaining 12 jurors may now retire, and you may begin your deliberations once Ms. Carly has brought you the evidence. So bailiff, if you will escort our jurors to courtroom 2,
Yes, sir.
so they may deliberate.
All rise. Call it.
Ms. Borkins, Ms. Nick, you can move up to the front row.
Ready for me, Judge Stearns? All right, good afternoon. I'm Judge Cole, Eric Cole, the district judge and juvenile judge for the county. And I believe we've got a couple alternates out here. I believe we've got Miss Ruby and Samantha, is that correct? And I'm not trying to put y'all on the spot this afternoon, but y'all care to tell us what your decision would be on this trial? What do y'all want?
Are we allowed to?
Yes, you are. Tell me what you would do on that case. If you don't mind, you don't have to, but if you want to tell me.
I would say not guilty for driving under the influence,
Okay,
and I would say guilty for the other 2 charges.
okay, all right. Any reason for the not guilty on the DUI? Do you want to expound on it, or?
I don't think that the evidence proved enough, because if there was no proof that it was reckless driving, and even known that it was 1 over for the blow test thing.
Okay.
I don't think that, like it said, that wasn't enough evidence, and I could not count that because he was driving fine and he was able to pull over perfectly fine. So.
Well, I appreciate that. Thank you for your, what about you, Samantha?
I would say not guilty for driving under the influence, and guilty for the other 2.
Okay. Anything different from what Ms. Hardy said? Or?
No, not really.
Okay, that's good. Appreciate y'all participating today, and normally we have about 200 students in the courtroom, and it's easy for me to interact, but as y'all my only 2 today, I got some administrators and some personnel, and we appreciate y'all being here and being able to participate, and thank God for modern technology, or we wouldn't be having this thing today, or being able to live stream, so appreciate our tech people too. Appreciate all the lawyers too for their diligence and job they did today, and appreciate Mr. Lowry participating. Sometimes it's hard getting defendants up here to participate in these trials because, you know, it's a little difficult because you're on public display. So do commend the lawyers for their time and efforts, and Mr. Lowry for being here and being able to participate with us. One thing I'd like to get to is, you know, what do we learn today? What guarantees in the Constitution does Mr. Lowry
we're provided with basic freedoms under the Constitution, in which one of them is the right to a public trial, which we had today. We had Mr. Lowry here with his attorneys, and we had a live stream in front of a live studio audience, I guess, for lack of a better term. We had a jury here. So he had the right to a public trial. He had the right to have counsel, which he had Mr. White and Ms. White here that represented him. And I know they did a great job, because they always do. They work in my court quite regularly, and I have to deal with them a lot. They do a great job. What else did he have a right? He had the right to confront the witnesses. You heard the trooper here on the stand, and Mr. and Ms. White had the opportunity to cross-examine the witness and make their points. He had a right to a trial by jury, which was out here that's rendering a decision now. So they're deliberating now. One thing I would stress to our graduating seniors, we do congratulate y'all on where y'all at, and we congratulate you on being able to graduate during these difficult times. Everybody's had to overcome some adversity. Hadn't been easy. Hadn't been easy for y'all. Hadn't been easy for us. We've had to do some things different in the courtroom. We did have glass up here at one point to try to limit some exposures. We would have witnesses up here to protect our attorneys and court reporters. So we had to do some things, and y'all had to do some virtual learning. And like I say, it's y'all got a lot to be commended for because of what y'all had to overcome. And that's a lot like things you're going to face in life. You got to be able to roll with it and adapt to it. And hopefully soon we're going to be over all this COVID and go back to normal. But things are going to pop up in life that's not going to be easy for you. So we commend y'all for being able to graduate. We hope you do great things in the future. We look forward to hearing about great things from y'all. As Judge Burns said this morning, you're going to make right choices, do the right things. Life's about choices. You can go down the right road and go down the wrong road, but make right choices. I got a few questions from some of the schools, and I got some attorneys over here Mike can help me with some of these questions. And I dare say I'm going to ask Mr. White this question. How long does it take a person to go to trial for a crime?
Well, it's according to what the situation is. On a case like this, he's given a citation by the state trooper, and it has a court date on it. He goes and hires an attorney generally, and the attorney will file a request for discovery. Y'all might have heard that earlier. We want to know what the state's got against the defendant, what they might or will use at trial, so we're entitled to see all that. It takes a little while for them to gather all the evidence. For example, the test results, the trooper may not have turned them in with his ticket. He may have them in his possession, so they got to take a couple of weeks to get in touch with him and get those items and other discovery, particularly if it's a felony. So a case like this probably would not come to trial from the day it got written for probably 3 or 4 months. Now, felonies, it takes longer because they're more complicated. I also practice in Florida, as does Sierra. In Florida, they take depositions in criminal cases. So once you get your discovery and know who the officers or witnesses are, you can set depositions, which, as you know, are out-of-court statements under oath in front of a court reporter. So those can take 6 months or so. Now, with COVID, Judge can confirm with COVID that it slowed our court system down. We didn't have any jury trials for a long time. In fact, I don't know if we had a jury trial since COVID happened or not.
Yes.
Mr. White, we have a question from the judge.
Question from the jury?
Judge Stearns? Judge Stearns, you want to explain what happened there for your?
Sure, as we have, as I explained in my final charge, that if a jury has a question, that they should write that question down and hand it to the bailiff and come back in. And sometimes we can answer and sometimes we can't. This one's just about whether they can review some of the evidence, so. And we're going to make sure they have the ability to do that. So if it had been an entirely legal question, then we might have been able to answer it, or we might not have. It just depends on what the question is. This one was pretty straightforward. But once we get a question, I have to consult with the attorney so we can all decide what our proper course of action is. Thank you, Judge.
Well, thank you, Judge Stearns. Thank you for that explanation. Thank you, Mr. White.
Yes, sir.
And Mr. White's correct. We basically, from the trial side, we have been shut down for the COVID. And even prior to that, our caseload is very voluminous. And it may take at least sometimes 2 years to get a trial to a jury, just due to the volume that we have up here. We do, of course, the defendant does have a right to a speedy trial, which sometimes they are filed, and we have to prioritize their cases. So if they ask for a speedy trial, and then, we kind of have to try to work with those to get those to get to the trial quicker. Next question I had, or one of the questions I had, it says, how do we decide who's on the jury? Well, this law day is a little more of a unique situation because y'all are pre-selected by the administration. But on a normal trial, we would have at least 40, 50 people out here in the audience, and then the lawyers would be able to ask questions. The state would ask questions, defense would ask questions, determine how they would, if any of them had any biases or, would be disqualified from being on a jury. And at that point, after we called that down, then there's a panel, and then the jury, the lawyers strike from that panel. They strike off the ones they don't want until we get the magic number of 12 jurors. So that's how that's done. And then another question is how long does a lawyer have to prepare for trial? Which Mr. White's kind of explained a little bit. There's a lot of moving parts that go into these trials. Like I say, he's got to get all his discovery, know what the state has, and get his witnesses and everything together, do his trial prep. So like I say, these cases don't move very fast, so he's got ample time to prepare for trial. Like I say, some of these felonies don't go to trial for at least a couple of years. And then one of these questions that says, who's going to be deciding the guilt or innocence of Mr. Lowry? Well, that's the jury. As Judge Stearns has told you, he makes the legal findings, but the jury will find the facts, and determine guilt of the defendant. This was a good question, or I thought it was a good question. It says, is the audience allowed to speak during the trial? No, the judge is usually in command of the courtroom. Now, sometimes you'll have some outbursts, and sometimes they'll get a little escort to the door if they stay, get too out of hand. But they're not allowed to speak during a trial. And one of my other questions says, how does one become a judge? Well, you have to be an attorney first. And of course, you have to have an undergrad degree. You have to go to law school, pass the bar exam. As Ms. White has just passed 2. She's passed Alabama and the Florida bar in the last year or 2 years. So she knows what it takes to be a lawyer, and you got to have a certain amount of years before you can actually become a judge. You have to practice law for a certain amount of time. I believe it's 4 years for district and 7 for circuit. Is that right, Mr. Stearns? And Judge Stearns? So you got to have some time of actual practice before you can become a judge. Then one of the other questions I guess is, how does a judge determine the length of time a person must spend in jail? If the case is tried, then whatever classification, whether it's an A felony, B felony, C felony, misdemeanor, A misdemeanor, B misdemeanor, C misdemeanor, you do have some certain classifications that gives you the actual sentence. length, like a life sentence, on Class A. There's a lot of factors that determine. You got habitual offender where he's got some prior felonies, and then we do have some presumptive guideline cases which determine the sentence length. There's a lot of little nuances as far as sentencing, but we can't, as judges, just make up a sentence. We have to go by what the law tells us to do as far as the sentencing range. And then another question I have says, is the judge appointed or elected? Well, can be both. I was appointed back in 19, and I was elected last year, so I just got elected, so it can be both. And another question that I had that I was given, can I overrule the jury? So if the jury comes back with a verdict this morning or this afternoon that I don't like, that's not the law. I can't overrule what the jury does here today. They find Mr. Lowry not guilty, he's not guilty, he's guilty, he's guilty. I can't overrule anything that they find today. Like I said, if they find him guilty, then the sentencing will be determined based on what the law says, and that's something Judge Stearns would do. Let me ask the students here, since y'all the alternates today, y'all have any questions that y'all can think of that y'all want to know about? Or you need to ask any of the lawyers, or anything y'all want to ask the lawyers?
How many years did you go to college to do what?
7. You gotta get your bachelor's degree, so that's 4 years. But he did his bachelor's degree in 3, so 4. I did 4. And then law school is typically 3 years, but you can do it like he did in 2.5. So you can shorten it, I guess, and do it in about 5.5 years. But typically, if you do it on just the standard track, it's 7 years just for the schooling, and then you study for the bar exam for about 2 or 3 months before you take that.
Any other questions? What about the administration? Do y'all have any questions?
The law has changed about becoming a judge. When I came out of law school in December of '79. I graduated a semester ahead of my class. There are a couple of lawyers here that graduated right there with me. You didn't have these parameters, or you didn't have to have any experience as a lawyer to become a judge. So right out of law school, we had a vacancy on the district court bench where Judge Cole is, and I ran for election at age 25 and was elected district judge. So you can see that it's changed now. For example, Sierra does not qualify to run. Back then, they didn't. You could just graduate from law school and run for judge, which was kind of silly, I think. It was good for me at the time, but that's changed in the last few years.
Thank you, Mr. White. Any other questions? Yes, sir.
What happens if you're asked to serve on the jury, and you get the little registration card, and the person doesn't show up for selection?
Well, that's a unique position for a judge, because normally jury summons is not invitations. It's not, you're supposed to show up. So technically you can be held in contempt, and the sheriff can come pick you up and bring you to court. I think the way that we handled the first one, I think Judge Stearns, is we asked the sheriff to go call the person and see why they're not here, and then probably would defer them to another term to come serve. As the sheriff will tell you, we don't have enough space to put people in jail for not coming, serving on the jury, which that's important. I tell people you need to serve on the jury. That's one of the things you can do as a private citizen to, I guess, for lack of a better term, you can actually perform or be in some type of service with the government. That's the only thing you can really do unless you run for office. So you can actually participate in the system, in the government system. We have a lot of people that expect, but a lot of the problems that we have is driver's license is how people are summoned or picked. And a lot of people move, or they, so we don't know if they've moved or just not coming by choice, so, you don't know, so you have to try to call them. Like I say, we can't put 100 people down in the jail for not showing up to court, because we just don't have room for them. But, we try to work with them, if it's blatant, then I'm sure we would have to do something. I don't think anybody's been put in jail for not showing up at this point that I'm aware of. So, but we do ask people to participate. We try to understand, because people do have vacations and they do have, some people have health issues. Some people have people they're taking care of, elder people they're taking care of. So we have to be, a little sympathetic on some of these things. So, but we do encourage people to serve on juries, because, like I say, it's important to be here. So I appreciate that question. That's a good question. Any other questions? Yes, go ahead.
Can you only be like a lawyer for certain cases? So if there's a particular type of case that you want to take, can you only like do for that type of area? Like, let's say you only want to work for like children's cases, would you be able to do that?
So you're not just specifically limited to, you don't pick coming out of law school and then you're stuck in that. But part of your ethical duty as an attorney is to be competent in what you're doing. So most attorneys do have some sort of area of specialization. Most of what I've done since I've been out of law school is criminal defense and family law and a little bit of personal injury. So I would probably not just take on some sort of big federal tax case that I had no idea what to do with, because I wouldn't be competent to do that. But if that's something I was interested in, then I could become competent in that. So you don't just have to be one type of attorney forever, but most people do have a specific area of interest.
And let me say, Mr. White and Ms. White, they're engaged in what's called private practice. Now, they're free to take whatever kind of cases they feel they can ethically handle. Now, the attorneys for the state, they are government officials. So because they're assistant DAs, they are prohibited by law from practicing any sort of criminal defense in the state of Alabama. So they cannot take a criminal defense case because of the nature of their position. Now, Mr. Ransom, he's a full-time public defender. He's a state official as well. So because he's full-time, then that's what he's limited to doing. So he's not free to go out and, say, take a divorce case. So that's the main distinction.
As these attorneys will tell you, being in a small county or small towns, that we had to take a lot of things. You have to get proficient in several areas if you live in a small town, because if you don't, you'll starve to death.
And if somebody came in like a medical malpractice case, we're not set up to handle that. You see all these ads on TV, well, multiply that times 2 months. And that's how many private lawyers or law firms there are that handle medical malpractice, personal injury, those type of things. They specialize in that, but that doesn't say they can't handle the criminal case. They certainly could. We just got a general practice, so we can really go into any area that we want to. Now, we choose not to if it's something special, like medical malpractice. I wouldn't touch a medical malpractice case. I would refer it to someone else, some big firm, maybe in Pensacola. We've got a firm in Pensacola that we're referred to, and up in Montgomery and Birmingham and Mobile.
But I will tell you, Mr. White and Ms. White, they do several things. They do criminal defense, they do divorce work, they do juvenile work, adoptions and probates, and of course, before I was a judge, I had to do all that too. And I did real estate, which Ernie would never. He didn't do a lot of real estate. He
had to cross too many T's and not too many I's to do that.
So we appreciate Ernie and what they do over there. Like I say, he does it. We have, in a small town, you just have to do a lot of different things, and there's a lot of things that you like to do, but some things you just have to do because you got to pay the bills. So that's just the way that works. Any other questions?
And I tell you, We got competent judges in this county and have had. I started practicing when Judge Webb, this is his picture on the wall, was still on the bench in 1980. And I've been through several judges since then. But I go to other counties, I go to Florida, Sierra's about to go to Florida, and our judges are at least as competent, if not more competent, than all the judges we're exposed to. And it's a pleasure to practice locally because you know your judges, you know your district attorney, you know your other lawyers. And in Pensacola and down like at Orange Beach, for example, all the lawyers have flooded to the water, just like people have. And there's just hundreds of lawyers involved in county, and it's just dog eat dog down there. And they'll eat you up too if you don't watch it. And it's a pleasure to practice here in a small town.
Thank you, Mr. White. Appreciate that comment. I don't deserve it, but I appreciate it. I'm sure Judge Stearns probably deserves it.
Great. I appreciate that. I'm making points with the judges.
Well, we try, our local lawyers, they do a good job, and we work well with our local lawyers because as me and Mr. Stearns, or Judge Stearns, we were lawyers for several years, and you know, we get in the courtroom and we do our job, but we didn't take it personal at the end of the day, and we're friends first, and we try to watch out for everybody, watch out for each other. So that's one thing about being a small local bar is we've got a great bar. So, any other questions?
You know that with the alternates, tell us about what you think about your jury experience today. I know you didn't get to go back and take part in the actual deliberations, but tell us how the experience was for you this morning.
Oh, it was not bad. I found the beginning funny with the white family and I thought that was hilarious. But
thank you.
This is not the first year that Joe and I have done battle.
Yeah, it wasn't as, I don't want to say it wasn't like as serious as I thought it was going to be because it was serious, but like it just wasn't as tough as I imagined it to be, you know? I don't really know how to.
We were under time constraints, as you know, so.
Yeah.
If you noticed, I stopped objecting to the state's questions at one point because we got bogged down. My daughter said, stop objecting. So I stopped objecting, and that takes time. And then the judge has to rule on those things.
Yeah.
That's what Judge Stearns' job is, and my job is that we have to make decisions, and sometimes, as Mr. White understands, that we don't rule in his favor all the time. We don't rule in the state's favor all the time. It's just, like I said, we just try to do our job just like he's doing his job, and like I said, it's nothing personal. It's just a job. Any other questions from our admin?
We appreciate Mr. Lowry. I think y'all acknowledge him. Appreciate him this way. Like Ms. Robinson. If the jury can't reach a verdict, Judge, you want to talk to them?
If the jury, if all 12 can agree, they have to agree whether it's guilty or not guilty. They don't get to take a vote 10-2 or whatever. In Alabama, it has to be unanimous whichever way. So if all 12 can agree and they hang up and they come back, that's what's called a hung jury, and they tell us, Judge, we've talked about it, and there's just no way we're going to be able to agree, then either the state or the defense can ask for a mistrial. And if there are instructions where we can send the jury back in and say, well, we don't think y'all talked long enough, go back in, talk a little more, and then let us know if you've made any progress. And if they're making progress, you can kind of tell, but if it's just no progress being made and it looks like there's going to be no unanimous verdict, then we can declare what's called a mistrial, which means what happens, the state will be able to retry the case at a later date if they choose to. So a new jury will have to be selected and the case will have to be retried. Yes, sir.
Judge, do they have to come to verdict on all 3 charges, or can they hang on 1 or 2 and come to verdict on a single charge?
That's a great question, and, of course, they can find Mr. Lowry not guilty on 2 and guilty on 1, or they can find him not guilty on all of them or guilty on all of them in any combination, but say they can't reach a verdict on the DUI charge, but they can on the other 2, then there could be a mistrial declared solely on that charge. That'd be a lot of talk for the attorneys to have to get together and decide what they want to do on it.
That's the reason a lot of cases, Judge Cole came out of the DA's office, so did Judge Stearns. My nephew Jim, who's the presiding respected judge, came out of the DA's office. And Mr. Billy's the district attorney, we met him this morning. We resolve a lot of cases before they get to this point. We evaluate the case from the defense side, we evaluate the case, or the state does from the district attorney side, and if we can reach some kind of agreement as to an outcome in the case, to dispose of the case. Like if it's a first-time offender, some minor charge, they might give us a pretrial diversion and keep it off the person's record if they jump through these hoops. Good, we got a person.
All right, thank y'all, and good luck, seniors. And as like Mike Tyson says, everybody's got a plan till you get hit in the mouth, so try not to get hit in the mouth. All right, good luck, everybody.
Okay, we will have our alternates. Why don't y'all move over to the front row over here on the green pieces of tape. And then,
Yes, sir.
yes, sir, Mr. Rosso coming back.
No, no, Your Honor.
And our court report.
It just happened.
All right. You will bring us to jury, please.
All rise.
All right, do we have all 12?
Yes, sir.
All right, please be seated. Who's our foreperson? All right. What's your name, please, ma'am?
Brianna McGowan.
Okay, Ms. McGowan, if you will hand to Bailiff Perry here the verdict form.
Okay.
All right, Mr. Lowry, Mr. White, Ms. White, who have Mr. Lowry stand? We, the jury, find the defendant guilty of driving under the influence, signed by Brianna McGowan, today's date. We, the jury, find the defendant guilty of failure to wear a safety belt, signed by Ms. McGowan. And we, the jury, find the defendant guilty of open container violation, signed by Ms. McGowan. All right, Ms. McGowan, was your verdict unanimous?
Yes, sir.
as to all three charges?
Yes, Your
All right, Mr. White.
Judge, we'd like to hold the jury, as to the DUI. Fine.
All right. The defense, which is their right, is asked to hold the jury, which I will go one by one and ask you if these are your verdicts. And we'll start on the front row here. Sir, are these your verdicts?
Yes, Your Honor.
Are these your verdicts?
Yes, Your Honor.
All right, last on the first row.
Yes, Your Honor.
All right, and the young lady in the yellow shirt, are these your verdicts? All right, next.
Yes, Your Honor.
All right, row behind, sir, are these your verdicts?
Yes, Your Honor.
All right, in there, are these your verdicts?
Yes, Your Honor.
All right, next row,
Yes, Your Honor.
okay, and are these your verdicts, ma'am?
Yes, Your Honor.
Ms. McGowan?
Yes, Your Honor.
All right, and over here on the end,
Yes, Your Honor.
okay, is that everybody, or have, okay, last there, back row, these your verdicts, sir?
Yes,
All right.
Thank you.
Okay, thank you, ladies and gentlemen, for your service. We want to express our gratitude to everybody. Thank you for your time and attention today. I want to congratulate you on where you are as a senior class about to graduate. Y'all got, what, just a few more days until you graduate. And it's very commendable with the past 2 years. And y'all have done a great job to get this far because it's been a trying time, whether you're going to be in school or at home learning virtual, or you're going to be quarantined because somebody sat next to you who may have been exposed. So it's a lot of stress for a lot of people, and I commend each and every one of you for where you are today. I want to thank everybody for being here, and y'all did a great job today. We appreciate you coming, and we could not have this program if it weren't for the schools here in Escambia County. So we want to thank all of the administration that helped put this together. So thank you all. Just briefly, does anybody have any questions about anything before we discharge and let you go back to school?
What happens if you don't show up and you got served as, this kind of spot?
If you get jury duty, if you get a card, well, what we do is we call attendance, as we call roll today, and if a person is not here, then we would give that information to Sheriff Jackson. And he would make contact to try to determine whether the person has an illness, or a lot of people have died since, and they're still on the roll. So legally, if you are just disobeying the jury summons, that is a court order to be here. If you are disobeying that summons, then you could be found in contempt of court and sentenced to jail for 5 days. But that has never happened as long as I've been here. We give the sheriff an opportunity to make contact. We try to speak with each individual, and we will set them off to another jury term. Judge Cole, you have never seen the occasion where anybody's been put in jail, but that's how important jury service is. So y'all did a great job today, and we appreciate you. Okay. Any other questions?